All present and correct?
Yes, ma'am.
All right. On we go then, Mr. Fraser, when you're ready.
Right. My lord, just overnight, I wanted to pick up on your eagle-eye point about the chairman's witness statement. You spotted in paragraph 40 in the second sentence, which is at page 1322.
Yeah.
D, that then potentially felt in the second sentence there should have been a not before solely, and indeed we checked with the chairman overnight, and your lordship is correct.
Right. Okay. Thank you.
Keeping that witness statement there, I want to just move on into the events of March and into 2019 and addressing some of those points made by my learned friend. The first point, and of course this is important in the context of affirmation, is that in March, and the payment was due by March, which we construed to be in a date in March or before April, we are seeking, we are pressing them, saying, can we have working capital? Where's the working capital? Them saying, well, it's coming, and but you must pay its first instalment. And we see that in paragraph 51 of the chairman's witness statement. Yeah. Just to pick up some of the details. 49, we start with 49. After the position deteriorated, then he discovers at 50 that North Bank is replaced, and then at 51 you'll see the passage we're relying on. Trying to keep us aboard, the banks kept stringing on a promise of working capital. I spent most of 2019 in London, but was relayed these promises. For example, Gail Hanlon told me of a meeting that occurred in March 2019, the day before the first instalment payment under the syndication was due. Your lordship just reads the rest of that yourself.
Yes. Yes.
So there, well, we are going to pay some money. They're making similar promises. We act, and then nothing happens. So that sort of evidentially supports what we say happened in December. But also, it's them saying money is coming. So are we to be in those circumstances? They've breached, or are we giving them more time because we're not acting on it? Is other extensions? Who knows? These are matters of fact that will be explored at trial. It's not black and white in that respect. Now, page 1100 of the bundle, which is back in that same, well, in my same hard copy, 1100, is the letter of the 27th of March.
Yep.
Written by advanced on the 27th of March, addressed to Emirates Banks as the agent, who's now replacing Noor. And it's, your lordship seen this yesterday. This is the letter in which we said there was a mistake by signing all our projects, and so they agreed 70%. On top of that, we overlooked the working capital requirements of the project for the sign to the syndicate. We're experiencing delays. And we need working capital, again, consistent theme, what it's needed for. We have discussed, 2 paragraphs under, we have discussed the above requirements with all participating banks. So that's evidence that the chairman said is correct, that they have been pressing for working capital with all participating banks, which would include Noor. We appreciate that everyone's understood our requirement and have shown inclination to extend immediate assistance for the mutual benefits of all parties concerned. So this is specific. So again, not inconsistent with our case that we need a working capital, and we're communicating this. And we understand that it will become, it's quite a lot, learned friends, well, you know, you should be seeking to rescind at this stage, and if you don't, it's all you've lost. But there's a huge amount at stake, obviously, here. And these are complex facts and complex legal facts. And so suggest that that by acting sort of weakly, if you like, or generously in other terms, or realistically, pragmatically, maybe optimistically, in seeking to pursue this route, we think it would be wrong to consider before trial at least, that we'd lost our right of affirmation. And so, in this course, this letter itself was written before the expiry date of the term of the OBN agreement. But the question then is, but it's a fair point, because on the face of it, it says we overlook the working capital requirements on top of that. But as your lordship saw from the email from Mr. Rishi Vig, there is an explanation for that. I think in the e-bundle that is at 4609, tab 97 of G. And we go forward to the exhibit. Actually, I don't really need to go much further. It is a bit earlier. It's a few days earlier, so it's not an explanation of this precise letter, but it's the same phrase. So the 24th, let's go to the email underneath that. Mr. Ejaz is saying to the banks, this refers to our recent telecom while closing syndication, we overlook the working capital requirements. And that's the same phrase. And Mr. Big
well, there's a difference, isn't there? Because 4610 refers to overlooking the working capital requirements of the 70% projects that are assigned to the syndicate. And then if you look at the 1100, we made a technical mistake by assigning all of our projects to syndicate instead of the agreed 70% of the projects. Only 3 projects remain outside syndication. So
yes,
what's the position there? What was actually assigned in terms of income? It's the income from the projects, isn't it? That was to go into the reserve account.
So I think that they had assigned, they'd intended to keep back 30%, and certainly from the terms of that, and they'd assigned all of them.
Well, that's what's said there. That's not what's said at 4610. It's a different point.
No. But that's there is that point, my lord. But and that's a matter of fact on what precisely was sent over. But the point I want to make is the question about whether what was overlooked or not about the working capital.
That's the point, isn't it? Because overlooking, technical mistake. I mean, a different story is being presented in each of those 2 documents on the face of it.
But not to separate people. The same people who are getting the below email, Mr. Isbaz, they're participants in the CIB Abu Dhabi, are participants in the. So it's not like there's any sort of obfuscation. See, they know if there is an inconsistency, they're going to see it and they're going to know what it is. I don't think there's a point to be made here about Mr. Ejaz misrepresenting the position. What I was trying to
well, I'm trying to understand what is actually being said about what the mistake was and what it was that was overlooked. That's why I'm asking the question.
I understand that, Arnold. If I can come back on that, but the point I wanted to say and to explain was that working capital, it's said against us. Well, if you said that working capital was brought up on the 16th of December, this letter of the 1100 indicates that it wasn't brought up because it said we overlooked it. We overlooked working capital requirements on the projects, whichever they were. And what I want to point out, Mr. Vig's email, the 24th of March, says actually we didn't overlook working capital. This is factually incorrect. We didn't overlook working capital at the time. Our understanding has always been to get working capital after closure of the syndicate bilaterally, which would be consistent with the chairman's evidence on the 16th of December. It was mechanism that needed to be finalized. Also consistent, it was a mechanism. They had the agreement, they handed over the security, and they needed to finalize the mechanism of the return. Were all the banks going to come in for 350 million, or was Norbank going to guarantee 100 million? And that, so we say those 2 sentences are not inconsistent with our case and explain, I think we say, are supportive of our case, of the defendant's case. And certainly the email here talks about borrowing agreement of 300
What's the
million.
borrowing agreement that's referred to?
That is the CTA, which has a clause at 19.5, which permits 350 million of working capital facilities
Yes.
outside. And so
Clause 19.
0.5, we can have a look at that now. It's at page 948. So the CTA starts at 884. And you'll see there that under the agreement, the obligers shall ensure the aggregate total working capital outstanding BAFM shall not exceed 350 million or the equivalent at any time after the 37, as reflected on the balance sheet. So it's permitting them to have up to 350 million, which coincidentally is the same figure as the chairman thought that no bank would be able to get out of the other banks. And normally these clauses have ratios in them, but here's a specific amount which is the same as the letter in the chairman's witness statement, as the agreement he suggests was reached. So there is some evidence here that they were, in this clause and indeed in that email, they were heading towards, or understanding was all the other banks would be coming up with 350 million, and within that, Norbank, of course, was guaranteeing 100 million. So
the argument being put to United Arab Bank is that 30% of the business that hasn't been assigned is not sufficient to give rise to adequate working capital. Yeah. And so they need the syndicates or individual banks within the syndicate to produce working capital, because they're getting the 70%.
Exactly. I think that's exactly. I think your lordship's got that.
Yeah.
So again, we say not inconsistent with our case in that respect. 1101. Just going through the 1100s. 1101, 14th of May. Um, 6 weeks or so on AMF group syndication. This is a meeting with members of the group, including Norbank, talking about the arranging of working capital limits specifically. The group CEO welcomes, at point 1 on 1102, welcomes all the participants and gives brief opening remarks on the overall company situation, stress on the need of working capital on an immediate basis. He presents the position and the requested facilities. Over the page, Norbank at 4 stressed the need for equity infusion. Norbank at 5 expressed their concern on the completion and latest assignments. But 6, nevertheless, all banks, that's including Norbank, immediately unanimously agreed to provide approval for aggregate of 150 million working capital by 31st of May in a couple of weeks. Limits are released for utilisation once equity infusion is reached through the account bank, and funds will be used to remove the downgrades. And NBS.
Well, this is all of the same tenor, isn't it?
Yes.
Okay, if you produce equity infusion as well, which doesn't happen.
Certainly the working capital doesn't happen. I don't know about whether the infusion was going through. We don't have evidence that it did go through.
Well, we have evidence from Mr. Ali that there was a willingness to produce working capital, provided that an equity infusion was made by the chairman.
Yes. So the parties.
So I think in different figures, I think, but
the
same idea.
So they're holding out for their side, but the chairman believes that this working capital will come, and he's not pulling the trigger on any court proceedings. We're talking here in the context of affirmation, because he's understanding that funds he thinks should come and will come. Now, they're demanding equity infusions. We'd say that was beyond what Norbank were entitled to demand, but nevertheless they were. They were sitting on these enormous sums of money we owed them. So you can see factually the position in terms of affirmation isn't as black and white as my learned friend would have you accept, put it that way. There is some consistency obviously with my learned friend's case that there was no promise, but equally some consistency in terms of our case of there were promises and we were seeking to try and hold them, but in the context of the situation, this we felt was as best as we could do at the time.
It's just my curiosity, Mr. Fraser, but I haven't understood what the removal of downgrades means. Appears in both paragraph 4 and 6.
Can I ask those behind me to inform me, because I don't know either. So going forward, on the 25th of July, we see this is another letter relied on by my learned friend, but we could equally say it supports our case, 1104. It's a letter to the global agent from AFM. I'd like to thank you for your continued support in regards to the facilities. Likely, as you're aware, the economic conditions have severely constrained the liquidity of many companies in the region. A recent lack of working capital facilities being extended to our group companies at this crucial time has had a spiraling impact on the operations of the company, and that's making a specific, polite terms, implicit accusation that you're not carrying out the working capital. We understood you were. This is really killing us. I'm informed that the downgrades were credit ratings with central bank, my lord.
Oh, right. Okay, yeah.
And so that sentence we rely on, and then the rest of it is whatever it is. We've employed Deloitte to support in the restructuring, getting a business report, letting out know what our operations are, we're committed to maintaining an open dialogue and keeping you informed of our progress through this, and thank you for your patience. So not inconsistent again with our case that the expected facilities have not turned up, and this is killing us. There is going back to the chairman's witness statement at paragraph in the same bundle at paragraph 52. He refers to an event in September. Whenever I met with the banks, I would complain about the failure to provide working capital and the bank's refusal to release operational funds from the revenue being routed through their collection accounts. And that's important because it suggests that it was never raised with Bank, their failure to comply or fulfill the agreement. But there's the evidence. Whenever I met them with the banks, I would complain about the failure to provide working capital, the bank's refusal to release operational funds. They would use similar tactics with me. For example, when the banks came to visit me in Guildford in September 2019, they're insistent that I sign a promissory note. This is one exhibit in the bundle at page 116. They told me if I signed the note, they would give me anything the BBH group needed. However, again, after they got what they wanted, they did not follow through. So more evidence, we say, of us trying to get them to enforce their agreement, them saying, yes, well, we will if you do this or you do that. Understandably, understandably, they're using their commercial muscle to do this sort of thing. But, and the chairman's position is very weak, but it doesn't say, we say we're not in a position of affirmation there. We have the Marist Report, which is at 1106 of the bundle. Now, this is a report on the financial circumstances. I think it was commissioned in August and reported on the 10th of October 2019. Now, my learned friend relies on this as evidence that there had been no agreement in December because there was no specific mention of an agreement for working capital. But actually, the wording is rather careful, we would suggest, in this respect, because what it says is, wording relied on my learned friends at 1109. On the left-hand side, you'll see some black writing. These are sort of headline points. There's a headline point relied on my learned friend. A debt restructuring, we'll see key messages. The top one we can leave for the time being. The bottom one, a debt restructuring of syndicated deal with 7 lenders totaling 1.7 billion did not result in any additional working capital facilities for the group, which is now facing significant financial challenges. Now, that's very careful wording. It's not saying it wasn't agreed. It's saying it didn't result, which it didn't, because none has been forthcoming. So as we say, that phrase can't be really played material in aid, or as my learned friend seeks to do, or that there was no agreement in December. And a similar point, careful writing, is at 1118 on the right-hand side. Again, relied on my learned friend, but just ask your lordship to note the careful wording. Halfway down, under the black headline, Jan 19 debt restructuring and syndication, it describes the syndication deal being financed. And he describes that the primary objective of the syndication, management advised the primary objective to be to offer additional security in Nbd loans in order to secure working capital facilities. However, whilst additional security was granted to certain lenders, no additional working capital was secured by the group. So the central purpose is additional working capital, but it hasn't actually materialized. And that, again, we say is as consistent with our cases as it is with my learned friends. Lastly, I think in this section, just ask the lordship to go back to the my learned friends, Mr. Chairman's witness statement in the same bundle, paragraph 53 to 4. Where he talks about things coming to a head. This is the my way or the highway evidence. Paragraphs 53 and 4 is a December meeting with the syndicate banks and the chairman. The lordship, just read that to yourself.
Yeah.
Again, the chairman's snapping here. He's complaining about the Norbank's and the bank's failure to comply with the terms of the December meeting by providing no working capital in exchange for security. I asked them to provide working capital to come to conclusions fair to everybody. Otherwise, I would go to court and prove that the Norbank and syndicate were the main elements of the collapse. I told the banks it was either that my way or the highway. I also at that meeting complained the banks had security for OBM, hadn't provided me the working capital for it. When I mentioned OBN, something strange happened. The lordship remembers this from yesterday. Representatives of the bank shifted in their seats. The atmosphere started to change. Well, previously there's been an argument between me and the banks. The banks started arguing with each other whilst I just looked at them. It became apparent that Norbank had not told the other banks about OBM. Now, the lordship yesterday made an interesting point, which is, well, how could he have understood it was just for all the banks when he had if he knew about their plan was for them to get the security. But if you go back in the witness statement, he at 42, when he's talking about his understanding, he is understanding already at 41. Norbank asked me why I was looking to other banks to raise working capital, not just on OBM, but they could look to us and the syndicate. They explained this to me as follows. They wanted the matter to succeed, so they would provide the working capital. So that they would arrange for 350 million working capital to be advanced to BBH Group by the syndicate if we provided the syndicate security over OBM so they could proceed. In response, I was asked for 450 million, so they would try to arrange, and it looks as though the figure was 350. But even if the 450 was raised, they would guarantee to provide 100 million. They would guarantee Norbank if the money comes in. So you can see, and that's why the chairman's thinking it's going to go to the overall pot. It may be, we've seen the internal Norbank documents, they're thinking it's just going to come to us. But in his mind, certainly at the meeting, and it appeared to persisted, he's thinking it's going into the overall pot. And who's in fact, you know, and it would have been granted to Noor Bank, but of course they were at the time the security agent, so that would be normal. They would hold it on behalf of the other creditors. And of course, in practical terms, under the CTA, they would in fact be held in security, even if it was granted outside. Should have been for the benefit of the other creditors. They were due to share a cascade with them, although my learned friends instructors are they haven't yet. So you can see that the chairman's understanding is not wholly irrational in that respect. And so we say that sort of quietness, element of keeping matters from the other banks is sort of curious and may want to be explored at trial. Anyway, that's so the chairman makes that my way or the highway, and then we don't pay the next instalment. And so my learned friend, and we do it in the context of the failure to provide working capital in exchange for OBN. So my learned friend's point in his skeleton to your lordship yesterday that, oh, well, we never even raised this issue until our defence is not correct, because actually you can see in December he's specifically raising the point and saying you've got to provide working capital or we're going to go to court. And that's actually where we've ended up. So was there affirmation in that period between April and December on the ways that I've shown it to your lordship? We would submit not. It's all a grey area. It needs to be investigated. Lastly, I think I'll just ask your lordship to reason about the impact to the on the group by Noor Bank's actions, the failure to provide working capital. Your lordship just reads those to yourself, 55 to 58.
Yeah.
So if we're right, what has happened is no small thing, and we deserve to have, we say, Mr. Chairman's opportunity in court at trial to make his claims good. Turning then to our legal submissions out of those facts, your lordship, and if I may just ask your lordship to pick up our skeleton, it's probably helpful to do it by reference to that and pick up points and cases as we go along. Paragraph 64. I might ad-lib from time to time, I hope your lordship forgive. Paragraph 64 gives your lordship the well-known rules on immediate judgment. No real 64 RDC rule 24.1. You can, if it considers there's no real prospect of conceding on the claim or no other compelling reason. There's pretty much the same as each other. We know those rules. Your lordship is very familiar. At 66 to 69 are the Wenlock and Maloney, Williams and Humbert and Three Rivers cases, and that's really the mini trial point. And I will make, I know we make it in our skeleton, I will make an overarching mini trial point. I'll do it lightly, but I think it is important to make it, which is that your lordship should really, the authorities such as Wenlock and Maloney and Swain do really say that your lordship should decline to proceed, shouldn't go down, follow an invitation to go down and embarking on a mini trial, because that's just isn't the right way to proceed. And you often are invited to do it, and sometimes you should just, having seen what it's about and the various matters, say, I just can't go there, I can't do justice in that way. And that's really the effect of 66 and 67 and Wenlock and Maloney. I'll develop that a little bit before I get there. I've given your lordship the quoting from Three Rivers that we rely on, and Lord hopes that, and the points rely on there. So I don't think I need to go back to that. Easy Air, my learned friend took you through, and I would obviously endorse, that is endorsed. You're looking at 3, and reaching its conclusion, the court must not conduct a mini trial. So to get to you shouldn't get to determination if you have to, by do so, come to a mini trial. That's Swain and Helmer. You're looking at 4 Five is important to take into account evidence that can be reasonably expected to be available at trial, particularly here disclosure of the defendant, the claimant's documents between them and the bank on the question of actual agency, of which we've got nothing. Although a question may turn out at trial, 6 is plain on its face from Office of Pharmaceuticals. Though reasonable belief, you should hesitate for making a final decision where reasonable grounds for exist for believing a fuller investigation in the facts of the case will add to or alter the evidence. And 7, you think there might be material existing. Going over to 71, Skurikin, and this is at 8. We set out the quote in Simon, the decision of Simon J. in Skurikin, and it may not be appropriate to decide difficult questions of law on an interlocutory application where the facts are not available, not out there, fully out there. And I think this is particularly apposite here for reasons I'll come on to. Obviously, Your Lordship knows Hexagon, where the above principles were effectively adopted in the Dubai courts, and indeed, Your Lordship in GFH Capital. And Integral Petroleum, we might just look at, which is Mulder J's decision about witnesses. And it's at tab 79 of the case file, page 4011. And it's paragraph Mrs. Justice Mulder's judgment. It's really about the comments she adopts made by Mr. Justice Burt in Cormac. Mr. Justice, in paragraph 100 and 101, Mr. Justice Burt said, he was talking about there's an expert report, but she applied it to witnesses. Mr. Justice Burt's quotation, I must say, if I take the professor's reports at face value, I believe they could be read in the manner proposed by Mr. Silverleaf. I'm not sure all Professor Oswald's explanation really face up to the true scope. However, what I'm sure about is I cannot say on this application, on the summary basis, and without having heard the professor and witness box, that his evidence lacks all credibility. No matter how much I may doubt the professor would face up to problems, I'm quite satisfied I'd not be right to rule on a summary application his evidence is so doubtful as to lack all credibility for that reason. And she says, although he was dealing with expert evidence, the principle seems to apply equally to witness of fact. And we would say, looking at here, can you really say that the chairman's evidence on these important issues lacks all credibility? We'd say it doesn't. So the Wenlock and Maloney submission, and this is at 75 of our paragraph 75 of our skeleton. And the way we put it is this: it's the overarching defence that Your Lordship should decline to go further, as Your Lordship has been invited to preside over a mini trial. The matter of impression for Your Lordship, but the authorities such as Wenlock and Maloney and Swain and Hillman are clear that Your Lordship to decline to conduct a mini trial if you need to do so to determine my learned friend's application. We say it's plain that my learned friend's application requires Your Lordship to do exactly that. You've got to weigh up competing witness statements. You've got to have a protracted and microscopic examination of the 2018 and 2019 documents. You've got to consider prolonged and serious argument on complex legal and factual matters of law, and then say, that's what you're being asked to do. And we say Your Lordship is entitled to say at an early stage, this is not the right path, and you refuse to do so. And we think it's particularly apposite here, as we say, where there is reasonable grounds for believing that more time, or as we head into trial, would assist this trial process, because of course there are gaps in the evidence and disclosure. There's more time for us to get witness statements. I know Your Lordship proceeded with this hearing and made a decision to do so, but we were hoping to get other employees' evidence before Your Lordship. We weren't able to do that, but we'd hope to do that before trial. Disclosure from the defendants will help us and investigate the unresolved gaps in the NOR documents and the promises made to us, those side promises that appear to have been made in Lordship, seen that, particularly opposite the sense of disclosure of the agency issued between NOR and the claimants and within NOR. We don't have anything about that. Then there's the question of the evidence on whether NOR has shared the funds of the, or has or will have to share the funds of the OBN security realization. My learned friend said on instructions that they haven't, and he doesn't see that they have to, but we haven't had a witness statement overnight on that point, so we don't know that that is what is going to happen. And we'd expect that sort of matter to be investigated, really, and that sort of thing would appear in trial, because it does lead to an important point of ratification and hence agency. And really, overall, your Lordship, and I think it's heading towards this understanding, or does understand, you're being asked to decide a number of complicated legal points, such as agency, affirmation, duress, collateral contracts, breach of contract, all of which are highly fact sensitive in essentially a factual vacuum. Facts really need to be explored properly at trial for all these mixed fact and legal issues. And that's even before we get to the Sharia compliance point, which not only need the facts explored, but also needs expert evidence to opine on them before your Lordship can come to any decision by direction of the Dubai courts. So, in summary, mini trials at this stage of proceedings, such as my learned friend's application, are wrong and should be discouraged and not encouraged. And thus, we should submit your Lordship shouldn't hear this application any longer, but decline to proceed. But even if your Lordship doesn't, I've covered the authorities. Those points are as applicable to the individual grounds as they are to the overarching. And so now I can ask your Lordship, I'll just do this one quite briefly to turn to paragraph 77 of our skeleton, which is that where we addressing the defendant's point that there's no real prospect. We have no real prospect of proving that the working capital statement was made on 16 December 2018. And I've covered that. I've made submissions as we've gone through, so I don't think I have to do too much about that. But you'll see the points we made at 78. The duress would remain in part in any event, even if we couldn't disclose that. Then we go to 79. Disputed issues of fact are not meaningful for determination, and that your Lordship's pick that up. 80, we talk about the defendant's chairman's being credible, and I've made most of those points in 1 to 6. I'll ask your Lordship to remember that. There's nothing that fatally undermines or contradicts the evidence. And I say, in fact, as I've said before, it's consistent with the background. Mr. Ali's evidence is, however, less reliable for reasons we give there, where he says he denies that there was any working capital discussed, and I've made my points about that at 80 orally, and you see them reflected there at 82, 1, 2, and 3. I've made the point at 83, if it was so straightforward as he says, why was the chairman there? And I made a point at 84 and 85 about the Al Salam issue. 86, I've also made the point about vagueness and being an unhelpful witness. And at 87, I've made the point about no other witnesses support his evidence. 88, the question about the documentary record, I've already taken, I think, your Lordship through my points on why we say that the intention to reduce the exposure is not such a strong point in their favour. Was working capital 88, 96 off the table? I think I've made my points clear on that already, that it was a live topic for discussion and was inevitable it's going to be brought up. And then at 93, the contemporaneous documents, we've made our points as I've gone through each of them on which they rely. I'll ask your Lordship just to refer to this, considering your judgment, the points we make there again, but I talk about some of the internal documents at 98. And then we get to 98.3. We lead to that Mr. Padge's email of the 14th of January. And sorry, these are the internal law bank documents. 99. The a commentary about we're not copied into the nor bank internal documents, and that internal documents, that's obvious, but also right to consider that there's no opportunity for us to say one thing or the other as regards that. And then we look at 101, the documents between us and them, and I've made my comments about those emails and how they lead, we say, actually to a document consistent with our case, which is Mr. Pjsc's 14th of January email. Reliance is also placed on the absence of mention of the 2019 documents, and I've made this a point about these documents. Overall points, it's not a killer reason, and the various points we make through A through F. I'll ask your lordship just to read that as we go through. See, I've made. The point at 1013EF, the explanation for overlook, we've beefed that up because we've been able to put into evidence that big email. Talk about our own difficulties at 102. So we say 103, they haven't come close to the threshold. I think the lordship understands that submission. Then the question of agency, which I think obviously is central to the hearing. Now, it's a key issue here because without showing that NOR, and we accept that without showing that NOR acted on 16th of December within the scope of actual or ostensible agency in making working capital threats, the withdrawal threat and working capital statement, we're only left with a counterclaim against NOR. We accept that. We make lots of skeleton submissions on this, beginning at paragraph 104, which I will come to. But I want to ask your lordship just to hear me on the big picture, if you like. The question of agency is always a matter of first establishing all the relevant facts before applying the legal agency principles together. We haven't nearly got, we say, to the first stage of establishing all the relevant facts in this mini trial. Only a trial judge can do that. What we can submit, your lordship cannot dismiss as impossible that the agency may be found at trial, especially when, as a matter of fact, the evidence suggests that NOR Bank was, with the bank's consent or assent, the focal point of all negotiations between the group and the banks over the syndicated loan transaction from September onwards. So they're right there. The syndicated loan agreement, the financial transaction, was due to close in December. It's closing at the end of December. And this meeting was an integral part of closing the process of negotiations of that syndicated finance agreement. It must be at least possible, we say, and not fanciful, in those circumstances, that NOR Bank came to that meeting with actual, whether it's implied or express, or ostensible authority from the banks to negotiate with us, during the course of which they made the unlawful statements for which the banks must also be held liable. Don't forget, we've had no disclosure of documents from NOR yet, including documents between the banks and them on actual authority, between them and the banks, and them and us on banks and us on ostensible authority. We submit that there must be enough from this general scenario for your lordship to consider that not fanciful that agency might ultimately be shown at trial after disclosure and cross-examination. So we then have two questions. Is it possible that NOR Bank's representative had actual authority from the claimants to come to the 16th of December to negotiate the terms of the syndicated loan transaction? If not, did they have apparent authority to do it? Now, the law on actual authority, we set out, and your lordship will be familiar with, just to remind you, of paragraph 106 to 7. An actual agency relationship arises where a person, the principal, confers on another the agent authority to act on their behalf. While often agency arises by way of a contract, as my learned friend would suggest, the existence of a contractual relationship is not a necessary incident of agency. Agency can result as a result of express conferral of authority, or impliedly where the principal, this is what we're going to rely on, places the agents in such a situation that according to ordinary usage, that person would understand themselves to have the principal's authority to act on the principal's behalf, or whether the principal's words or conduct coming to the knowledge of the agent are such as to lead to the reasonable inference the principal is authorising the agent to act for the principal. The Lordship will have that in Bowstead at page 4231 of the bundle. I don't know if the Lordship wants to go there. That's where it comes from. So you have at 227 on Bowstead, where there is, you can have express agreement to confer authority, where there's an express agreement between principal and agent, this will constitute the relationship. Or you can have an Article 8, 229 agreement between principal and agent to confer authority may be implied in a case where one party is acting towards the other in such ways it is reasonable for that other to infer from assent to an agency relationship. And over at 231, as the quote we rely on, assent to the principal may be implied where the principal places another in such a situation that according to ordinary uses, that person would understand themselves to have the principal's authority to act on the principal's behalf, or where the principal's words or conduct coming to the knowledge of the agent such as to lead to the reasonable inference the principal is authorising the agent to act for the principal. So it's implied. Is that likely to emerge at trial, or is there evidence to suggest it will? So what we're emphasising is that a contract is not necessary for an agency situation. Rather, it can arise out of the express conferable authority or implied, whether we've been placed into a position. So it becomes a question of substance and is fact sensitive. My learned friend makes a pleading point, says, well, we haven't pleaded any underlying facts, but it means that an agency plea could be struck out and so forth. But it's not relevant here. This is a defence to immediate judgment. We put forward matters in argument the Lordship considers could give rise to agency, and obviously defence should be allowed to proceed. And my learned friend has in fact even asked for any particulars until today, and it was going to ask to do so. We could make the following points, but I'll make them to your Lordship, and your Lordship consider then whether we made out a real possible case. So what are the facts and matters we rely on? I think this is the key point to give rise to a prima facie case of actual agency. In essence, we rely on evidence suggesting that from the signing of the IMLA letter onwards in early August to the signing of the finance agreement in late December, Noor Bank was the arranger of the transaction and the focal point of all negotiations concerning the syndicated loan agreements. Now, in this respect, the appointment as the lead arranger is not relying, my learned seeks to characterise it as making Noor an agent for the banks in law. We understand that, but it's rather putting Noor Bank into the position of arranger for the next 4 months, during the course of which time that position was adopted, or Noor Bank was adopted by the banks as their agent for the purposes of negotiations. That's really how it's characterized. And you can see that if we just pick up the letter of being put into position at 260. What it's actually doing is 9.1. Sorry, it's 260 going forward to 263. This is as good a description of what it was to do going forward. And so far as we can see from the limited evidence, what it actually did, shall in consultation with the advisor manage all aspects of the syndication of the facility, including timing, selection of commercial financiers, the acceptance, allocation of commitments, and the amount of distribution of fees to financiers. So that's it places it front and central. And of course, it does become under 1.1 becomes the, and the other description becomes the arranger and coordinator of the facility. That's A, the book runner. It becomes documentation agent, account bank, investment agent, publicity agent, and security agent. Of course, in due course, security agent will be holding security on behalf of the creditors rather than for the lenders. Now, for the creditors rather than for the borrower. Now, my learned friend makes the point. Well, under these agreements, normally speaking, this is acting. It's got fiduciary duties or duties to the borrower. That's what, and you normally expect to see that in the authorities say, normally speaking. But here, there's a specific contraindication at 11.3C4, little Roman 4, page 265. Initiating mandated lead arranger or the bookmaker is not acting as a fiduciary for, as an advisor to it, that's to the obliger in connection with the transaction. So it can't be suggested on the fact of this lead arrangement, it was acting as an agent for the borrower, rather than as clear as it was, rather than the agent, rather than the lenders. Now,
fiduciary and advisor.
Yes, but it is a contraindication in those respects. Now, what do we have? What documents? There are documents after this, a limited amount, that do show nor carrying out these central position roles. So we see, and the Lordship seen these in September. It negotiates the term sheet. You saw the term sheets going back and forward. Other banks are at this point are cognizant of this, and it's NOR and the B/H group are doing the negotiations of the term sheet. It's exclusively between them, the documents going between them. After the term sheet, you can see Mr. Ali himself actually sets out NOR's central position in paragraph 41(2) of his witness statement. As good as description of where it is as any, which is in page 123 to 124. By this point, the documents were largely ready to allow NOR Bank to launch the syndication process and begin to find other banks who would lend. The invitation letter.
Sorry, Mr. Fraser, which paragraph?
41.
Thank you. Yep.
The invitation letter would be sent to banks, was prepared in October 18 and November 18. NOR Bank received various commitment letters from several banks. We'll come to those. On the 28th December, ENBD sent an email attaching ENBD's commitment letter. ENBD had committed to a participation amount in accordance with the term sheet. Of course, they were committing to a process led by NOR. On the 28th November, National Bank of Federa did the same thing, their commitment. 42, the team at NOR Bank dealt with inquiries from the banks and the other administrative tasks necessary to put together the syndicate. By mid-November, drafts of the critical syndication documents, such as draft common terms agreement, conventional facility, and Islamic finance, have been prepared and were being reviewed by the parties. So this is NOR Bank central to this process, as you'd expect. Some of the documents we can see in the bundle further ahead. At page 640, we see NOR setting up a documentary portal. There's an email from Mr. Khan to Mr. Edgehouse, September the 30th. Dear Ms. Bird, we discussed earlier, we are of the opinion that in the interest of all stakeholders to allow smooth flow documents, we would prefer to use the online secured portal of debt domain. There'll be a lot of to and sharing of documents, large files that easily be done. They stakeholders can have access and you can have process. Of course, we'd obviously like to be able to get disclosure of what was in there for during this process or have a lot of relevant documents. But they're in charge of that. The commitment letters are at 643 that we've seen. The Those are the ones referred to it as witness statement. They're at 643 from CB, and then at 650 from NB, 649 from NBF. And that is certainly, we say arguably, is acknowledging their position, saying we're part of this process, you're leading it, which is both potentially going to lead to implied authority and potentially to the sort of holding out to us. We're committing into this process behind law. We see it going into the bundle, defendants 1, 3, 4, 5 of the bundle. Which is in D. You see contact being made from a Norbank to NBF about the terms of the facility and sharing that information with the BBIH group. This is the process they're trying to lead. At one, going ahead in the documentation at 1347, you see Mr. Khan has the facility documents. That is the ultimate documents which are negotiated and then signed at the end of December. Adnan Khan is sending them to BBIH group, saying, here, find the attached facility documents. These are being released to the banks. Please review. This is one of the two documents that goes on to the chair. So that's being sent out and coordinated by Noor. And then 1349, there's quite a good description of Noor, what Noor's role was, effectively shared with everyone. So this has been put into the board at 1349 from Noor Bank, Mohammed Afiq Shafi, to the undisclosed recipients, and the debt domain email. So that'll be telling everyone what they're doing. And it sets down the timelines with a view at that stage, which is on the 13th of December. They're hoping to close on the 20th. Also, you can see that 13th December, finance provide feedback on security docs, finance provide NOCs, Noor to respond to all queries. It's going to be discussing those with BBIH group. First draft of legal opinions to be shared with the financiers. Final facility documents, legal opinions to be shared with financiers. Final amendments to be reflected, pre-execution signing facilities. So in all of this, Noor is in the middle of all this, involving itself with, in order to complete in a short period, with negotiations on the banks and therefore also with BBIH. So it's right slap bang in the middle, and this meeting is right in the middle of that, 16th of December. So we'd say, we're obviously, and this is important, it gives you how compressed the timescale the thing had got to and how imminently the contract was going to be signed when we had the meeting. We're obviously missing a large amount of documents between the banks and Noor, but we think the evidence I've showed your lordship says at least possible that we will show at trial by the 16th of December, and shortly before the agreement was due to be concluded, that Noor Bank had actual or implied authority to negotiate further the terms of the syndicate finance facility from the banks. It must be arguable that attending that meeting on the 16th of December was within the scope of that authority. In this principle, they came to the Noor Bank, came to the meeting as lead arrangers to try and negotiate a deal whereby the syndicate finance agreement was saved by BBIH agreeing to give the extra OBN security to Noor. Very interconnected. And indeed, as we say, not as interconnected, very complicated and fact sensitive. and for that reason, not really suitable for summary dismissal. And of course, the ABN did actually, was actually for the benefit of the closing of, was actually for the benefit of syndicate finance, because Nor would have been obliged under the CTA to share the proceeds of any such security for the syndicate. We make our points on that at 120 to 125 bars careful, though it appears they haven't actually yet done so. So we'd say on actual authority, not a fanciful case that your lordship can safely throw out at this stage. Now, as regards ostensible authority, we think the above Bacton matters support ostensible authority and rely on all those facts and matters. And we say that the fact that the evidence suggests the banks were happy to have Noorbank act as the lead arranger throughout this 4-month period, including negotiating the closing terms of the syndicate finance agreement and organise everything else, must be capable of amounting to holding out. Can I just ask your lordship just to look at Boasted on this, which is in the case file at tab 90. And beginning, it begins at it's chapter 3, authority of agents, actual and apparent. Article 22. We're really looking at apparent now. 3001. The authority of an agent may be B, apparent, where it results from such manifestation made by the principals of third parties. I want to pick that up over the page at 3004, apparent authority. Under this doctrine, where a principal represents or is regarded in the law by the law as manifesting that another has authority, the principal may be bound as against a third party by the acts of that other person within the authority which that person appears to have, though the principal not in fact given that person authority and limited the authority, no such is not known, so much so obvious. Going over to use 3005, usual authority. The case has been made for adding a third type of authority, usual authority. This has been defined by one writer as the authority which a person normally possesses in certain circumstances to act on behalf of another person, whether or not he's actually authorized to act. And they explain the expression usual authority is referred to in 3 contexts. The first 2 of which are uncontroversial. Is one of those 2 that I want to. And it's usually discussed as a subcategory of each of the actual and apparent. As a type of implied, that is the sort of authority that I discussed earlier, but they're put into a position that carries with it a certain authority. It impliedly has that authority. But 2, as a type of apparent authority, apparent authority seems to involve 2 types of cases where there can be said to be something like a specific representation by the principal of the agent's authority, which the third party would like, which could be called cases of genuine apparent authority, and cases where the only representation made by the principal lies in putting the agent in a position carrying with it a usual authority as described above. In both cases, the second one really, in both cases the principal is liable despite reservations in the authority uncommunicated to the third party, but the 2 could be differentiated as apparent or usual authority in this respect. So it's putting them in a position that they see as a type of apparent authority. And we say it certainly, as your lordship seen, the chairman's evidence at paragraph 45, 47, that he was dealing with Noorbank on the other bank's behalf. Even, as I said, thinking the ABN securities has been given to the other banks, was been given to Noorbank qua lead arranger on behalf of the other banks, i.e., as I've said, increasing the overall security in the pot rather than to be kept more separately. Possible he interpreted that way, or though Nor thought it was another. As I say, he may have been right in practice, as it was holding it for other banks under the CTA. And of course, as I've said, it could have been consistent with handing it to Nor because it's security agent I would have held for everyone else. Now, is it the strongest case you've ever seen on holding out? No. But is it arguable? Can you dismiss it at this stage? We would say yes. I think it is arguable. You shouldn't there is a real prospect, not fanciful, not without foundation, of being able to show it on further investigation. So those are points on ostensible. I just want to discuss briefly the question of ratification, because this really is an unresolved position, but I think I should make some submissions on it. We pick up the points, the law at paragraph 110. Even where a person, sorry, 110 of our skeleton. Even where a person acts without the authority of a purported principal in interacting with a third party, if the party believed the act to be authorized, the principal may subsequently, as my client did, principal may subsequently ratify the act and make it valid and effectual. And that is in boasted that I'll take your lordship to. Ratification may be implied, and receipt of money is an obvious example of ratification. They must normally have full knowledge of all the material circumstances in which the acts are done, unless they're taking a risk to ratify it, come what may. And you have the Sahota case where you ratify agreement without bothering to ascertain its terms. They're nonetheless bound by the terms. And of course, the principle, you cannot ratify an agreement selectively. You have to adopt the whole transaction, including the unlawful bits. Now, on the facts, my learned friend on instructions, it says it hasn't, the relevant ratification hasn't happened, but we just don't know that actually as a matter of investigation. And of course, if they have, then it's arguable they have ratified the collection contract and torts, and they're liable under them. So that is the position your lordship faces as a matter of fact. We make those points at 120. Looking at the benefits they would have occurred as obtaining the security. And this is really the point. My learned friend said, well, they didn't have any obligation, but our reading of the 25.1 of the CTA is covered at 121. Under clause 25, the finance party receives or recovers any money from an obliger other than in accordance with clause 26 and applies that amount to a payment due under the finance documents, then the recovering finance party shall within 3 business days notify that they're then going to be a cascade. So our submission is it has to be shared. If so, and it has been, then they would be in receipt of funds potentially for them to be distributed under the CTA. Have they? We don't know, but they are aware of the implications because they've exhibited some legal advice. More documents would help us on this point, but I don't think, as we say, I don't think the lordship can dismiss it as fanciful at this stage. It is a troubling issue that needs to be further looked at. On my learned friend's skeleton, he made a couple of points. I just want to look at paragraph 71 and clear something up. And he makes the point, well, the third party rights would be barred. Rescission would be barred, would defeat third party rights, but that's only if it wasn't an agent. If it was an agent, then this paragraph would be, as we argue, if there's evidence that it was, then it wouldn't be so barred. I think that's the important point to remember on that. Now, paragraph 73 on vicarious liability, we do accept here that vicarious liability stands or falls with the agency point. It isn't pleaded as a separate point, and we're not going to pursue it as that. So lordship shouldn't be troubled by the question of vicarious liability. My lord, can I then turn to the other key point, which is for today, which is the affirmation point? I think is the key issue. We cover this at a paragraph 185 to 187 of our skeleton. which I'll come to. But what we say, it's plainly arguable that on our case, the group's right to rescind only arose after the end of March 2019. So it is only events after that point that could give rise to the question. I'm so sorry, I'm so sorry, I'm in a hearing. It's only after that events that could give rise to the question of affirmation. Now, my learned friend relies on several events after that date until October 19, paragraph 84 of his skeleton, which I'll come to. None of them is an express affirmation by either affirm the contract or notice of affirmation, but it is an act that must be construed as affirmation or not. The argument being that each act was a treatment of the contract continuing, taken with knowledge that the group could otherwise have rescinded. Self-evidently, we say affirmation in these circumstances is a question of fact, primarily unsuitable for summary determination. Indeed, as I've just shown your lordship, the situation after March was not nearly as clear-cut as my learned friend would have your lordship to believe. Those are all the passages, the chairman's passages of paragraph 51 to 54 of the witness statement, in which we saw the demands for requests and demands for more working capital in spite of it not being made, consistently been brought up by the chairman. And we see, going to our skeleton, 1862, the claimants never expressly affirm, I think it should read, the defendants never expressly affirm the syndicate percentage agreements, meaning it must be implied. The chairman's evidence throughout the relevant period, they kept on stringing along with repeated promises of working capital. Once that was required, no working capital was forthcoming. At the same time, whenever the chairman met with the banks, he was complaining about the failure to provide working capital and the bank's refusal to release operational funds from the collection amount. In these complex factual circumstances, it cannot be said that the defendant had no real prospect of establishing they did not affirm. For example, given the above, it's not clear when factually the chairman realised the working capital representation was in fact false, since for some considerable time after the facilities were entered into, he believed or led to believe that working capital would be forthcoming. He put it another way. It raises the question of whether by, as I alluded to earlier, by generously, optimistically, or just weakly giving Nor Bank and others endless more time to provide the working capital, was he granted them extensions to the deadline, working capital deadline, so they were not in breach. In essence, if the working capital had come in, even later in 2019, we'd likely have treated that as performance in a matter of practice. The fact is, we only gave up on them after the December 19th meeting, when they provided no working capital after, and we refused to pay, and that's before they accelerated the events. And you see paragraph of our skeleton. So that this position is complicated enough to work out for us as lawyers, but even worse for the chairman, who's got no knowledge of the legal rights of rescission, as his evidence suggests. Now, and you do have to, as paragraph 1861 is, you're held not to have of our skeleton, you're not elected to affirm a contract unless you have knowledge of your right to choose between the alternatives, said the answers he didn't. Now, my learned friend suggested, well, everyone knows about the rights of rescission, but they're not actually, and they're all the same. But of course, there's under UAE law, Article 185, which is in the bundle, my lord, at the end, I think it's 49D. Article 185, what they say is misrepresentation is when one of the two contracting parties deceives the other by means of trickery, leaves the other's consent.
Where are you reading from?
185 of the UAE articles.
Yes, where's
So
the UAE? I haven't got the UAE.
Oh, I'm so sorry. You should be going to page 4605 AY. If you tap that in. 4605 lowercase AY.
Yes.
And you'll see there that under UAE law, for example, effectively you only get rescission for fraud, not for as you can for negligence. And here, under 185, misrepresentation is one of two contractual parties deceives the other by means of trickery, and 187, or if one of the others makes a misrepresentation to the other, which has been defined in the files, the contract was concluded by gross cheat, the person may cancel the contract. So it's not clear under UAE AE law, for example, that you can do that without fraud or without what they call gross cheat. So it's not always the same. It is a complicated matter. It's complicated factually. It's complicated legally. So is it suitable for Lordship to come to determination? We couldn't. It's obvious we affirmed. We'd say not. Most of the documents I have gone through already to show your Lordship contain a suggestion that we were complaining about not receiving the working capital, and that there is evidence of the promises of more working capital. We understood there'd be more working capital, and we rely, for example, on the letter of the 27th of March at 1100 and the minutes of the meeting at 1102 in particular in that respect. Now, my learned friend, it's wrong to say that we continue to affirm the contract until the defence and counterclaim, because of course we have the December meeting, is evidence of him complaining about their failure and saying, my way or the highway, we've got to come up with working capital or it's over, we're going to court, and they didn't come up with the sums. My learned friend is his skeleton at 86. Makes a point that they seek rescission of the alleged collateral contract to provide the OBN security. While they dispute there is any such contract, the evidence is the security has been enforced, that cannot now be unwound. That is maybe, but it doesn't affect the overall contract being rescission, being unwound. They can't rely on their own wrong in obtaining the security and then selling it to avoid rescission of the overall contract. And the Lordship will know that as a principle. If there's any doubt about that, it's paragraphs 38 to 39 Borellian Ting, which is in tab 50 of our.
Sorry, I'm not following that point for the moment. Could you just repeat that?
Yes, I'm so sorry, madam. What we say, I found it.
It's paragraph 86 of
yes,
the skeleton. Yeah.
They say we're seeking rescission of the alleged collateral contract. So that cannot now be unwound. Yeah. And we say whether or not that's the case, it doesn't stop the overall contract being unwound just because they've taken advantage of our wrong and taken the security and executed it. It doesn't protect the overall contract from being unwound from rescission.
Well, that's begging the question, though, isn't it? Why are you able to rescind the facility agreements when your complaint is about the collateral contract?
But that's because they are part of the overall web of events. That's the MARM case. They're part of the overall. I was going to come on to that.
Oh, right. Well, look,
I'll come on to MARM. Why we get on to that. So I'll come on to the MARM case in dealing with collateral contract, if I may. We'll see the point, as it were, in reverse. Yes. Then, just dealing with the way my learned friend has dealt with it in that order, if I can, I'm going to come on to duress. There's no prospect, it is said, of us showing that the economic pressure was illegitimate. Now, as we've made clear in our skeleton, we rely only on one form of illegitimacy, here, namely that Noor Bank's substantial economic pressure on us to hand over the OBN on the 16th of December was a breach of the best efforts clause in the lead arranging letter. The law in support of that, of duress in that respect, is set out in paragraph 140 and 141 of our skeleton. We begin at 139 because we had pleaded two types, one of lawful pressure, or rather lawful acts but illegitimate, and one of unlawful. We accept we can't, after the Times travel in Pakistan, continue to pursue the lawful act, so we're only pursuing the breach of contract. So was there a breach of contract, or what's the clause, and what way does your lordship look at it? And the law in support, paragraph 40, while the scope of obligations was about what does it mean best efforts? While the scope of obligations owed under a best efforts or best endeavours clause will in every case turn on the proper construction of the individual contract, such clauses as typically held to impose a heavy obligation on the persons undertaking them. Per McGarry in Pip's leisure, best endeavours are something less than efforts which go to beyond the bounds of reason, but considerably more than casual and intermittent. We just pick that up. It's at page 2262 of the bundle.
Well, I'm not sure we need to go there, really, do we?
No, if your lordship's happy with that, then we don't need to go there.
I mean, I'm reasonably familiar with.
You're familiar with that. And then over the page, it sometimes requires a party to act contrary to their own financial interests. They considered that in the Court of Appeal in the Jet 2 case. In that case, the court held the obligation of the obligers to use best efforts could in certain circumstances require them to act contrary to their own financial interests. But ultimately, it's a highly fact-sensitive question. And it's those two passages there, if you ask your lordship just to read those more big and then long more.
Yes, yes, I've read those. It's I mean, there's a great deal of debate about this aspect.
Exactly. So there is a great deal of debate. Is it suitable summary determination? We'd say no, it's a complicated issue of law. Now, the IMLA letter, people can go back to that, which is the contract we're going to have to construe at 260. We, Noor Bank, Pjsc, Emirates Nbd, and the book runner are pleased to set out in this letter the terms and conditions on which we are willing to use our best efforts to arrange and manage primary syndication facility amounting to 1.7 billion. Now, just stopping it there, that's the obligation. Then my learned friend says, well, immediately nothing in this letter constitutes a commitment by IMLA to provide any financing. So that automatically tells you that whatever best efforts are, they don't include under any circumstances the provision of capital. Now, what we say, their construction, that it's containing a statement that it's as to its own lending can never be a breach of its best efforts, it goes too far. The purpose of the second paragraph, properly construed, is to make explicit that the letter in itself is not a commitment to lend. Correct. It cannot be saying and dictating that in all circumstances, or the circumstances as pertaining as of the 16th of December, the question of its own lending as part of an overall factual matrix could not be taken into account by the court in deciding whether it was best efforts or not. We say that if the claimants, we say at 145, if there was construction was correct, then they could have carte blanche the whole of syndicate hostage without breaching its own best efforts. It held security over the labour camp, so its refusal would stop the syndicate proceeding. By committing to provide security over at the same time as appointing Noor Bank as the lead arranger, this was in August, we put our fate, so to speak, in their hands. Conversely, they were getting paid money to take this role. It was a valuable lead arrangement role. These are complex, interconnecting commercial matters with obligations on them. Does it have complete freedom, as we say, to act as it will? No, because the law, as we've seen, can require you to act contrary to your financial interests as part of a best efforts, or you perceive to be your financial interest. So they were the lead arranger. As to the question of whether Noor Bank could, in any given circumstances, breach its duty in threatening to withdraw from the syndication, has got to be fact sensitive, as we say in 146, inappropriate for dealing with it. There must be a real prospect for constituting a breach of duty. And the claimants make much of the allegation it was always their intention to reduce it, but that wouldn't be relevant to construing the scope of the duty. In fact, it looks like they only said this at the very end. Your lordship should not forget that the illegitimate economic pressure was not just a threat to withdraw or not commit, but also a demand to get the OBN security for itself as part of that threat, which also potentially prejudiced the future completion of the syndicate financial agreement. Those two aspects to it. And so again, surely a question of fact whether a breach of the best efforts. My learned friend relies on an extract in Chitty. It says that in paragraph 91 to 92 of his skeleton, a mere threat to contract is never illegitimate pressure. But I think he'd have to accept that it's obviously qualified by whether you are subject to another duty. If you are not, then plainly a threat not to contract cannot be legitimate. But if you are, we say as here, then the principle cannot be applied so baldly. So those are our arguments on duress and why we must have a prospect. You can't be kicked out at this stage. Now, my learned friend also made the point of saying we had no realistic prospect of showing that the alleged economic pressure caused us to enter the agreements if we also plead that we could have got the same facilities elsewhere outside of the OBN security. And he said this is not just a pleading point, but we really think it is a pleading point. We cover it at paragraph 158 to 154, 148 to 154 of our skeleton. I'll ask your lordship just to read that to yourself, and then I'll make my.
Yes, I've read that.
So our pleading is that Noor's illegitimate pressure caused us to enter the facilities for the reasons we give. We say we had no choice about that, and the lordship's seen that paragraph. Chairman's witness statement, paragraph 47, is paragraph 68 of defence. We're not anywhere saying as part of that we could easily have got facilities elsewhere.
Right.
What we are saying, it's a question of loss. We're trying to measure our loss. And we're saying in the defence is that our loss should be measured as if the tort had not been happened, as if we had obtained the terms without the OBN security being provided. That's what we're saying there. So there isn't this sort of TE point. Now he says, well, if there was no alternative agreement, if we accept there's no alternative agreement there that we could have entered into, we can't show loss. We think that must be could easily have obtained. This must be absurd. If true, it means that few economic duress claims could show loss, as they mostly require no alternative, no choice but to be forced into it. We can show loss, we say, by the tortious measure being put into the position as if the tort had not occurred. i.e. syndicate agreement without the OBN
But
security.
this raises the point that I was asking about earlier, Mr. Fraser.
Yes.
What you're saying is, and the chairman's evidence is, that he wanted these facilities, but he didn't want to have to put up the ABN security and was pressurized into doing so. So the duress relates to the provision of the security and the agreement to do so and the actual doing so. But you are going to enter into the facilities in any event. So the facilities aren't the subject of duress at all. It's the provision of the security that's the subject of duress.
Yes, but the provision of the... Yes, sorry.
So the effect of that is, as I understand it, assume you're right on the duress point, then you would be entitled to set aside that, subject to it all being fulfilled and the difficulties, or alternatively, you're entitled to damages in relation to the duress that's been suffered, and that gives you a cross-claim, but it doesn't give you a defence on the facilities themselves.
Now, in principle, mostly we would accept that, but except for we would say that because the OBN security, the duress in relation to that, is part of a web of contracts. This is the MARM case.
Well, I understand you say that. I need some persuading as to why the two can't be seen distinctly. It's not as if one is consideration for the other.
Well, maybe I would then go to the MARM case and then
Yes,
make my submissions to that, because I feel this could be where we're at. Now, the point about the partial rescission is, and we say, is that it's not, hasn't yet come with us that it's part of a web of contracts, and I think I can show those it is. And just looking at the MARM, it helps if we could go to the MARM case, which is in case file 75, page 3673.
Yeah.
Now, in that case, Maud and Quinlan's vehicles will begin on the first page. The first page of that. Maud and Quinlan's vehicles had entered into a senior loan agreement and were required to enter into a swaps agreement as a condition of that by the banks. And you get that under paragraph 5. The action concerned the question of MARM's liability to make payments to the defendants in relation to interest swaps entered into by MARM on the 12th of September. The context was in the purchase of Sudad financier by MARM, which was financed in part by a loan of 1.575 billion by a syndicate of 8 lenders, including the defendants, the senior loan. The terms of the senior loan required MARM to enter into hedging arrangements in relation to the interest payable. The swaps were entered into to satisfy this requirement.
Yes. 6.
MARM seeks rescission of the swaps and damages up to 996 million. He was not seeking rescission of the senior loan. At 332, we can pick it up. Paragraph 332. We come to the question of
what page is that?
It is paragraph 332.
Yeah, have you got a page reference?
I will my those here
right.
behind me.
Don't worry, I'll
no, I will. I'm just gonna go this page and the next, but I'm gonna.
It's just that using the cursor takes longer.
Yes, I agree, and we are there. It's 3806.
Thank you. Yes.
So he's decided actually, in that case, he couldn't get rescission because of affirmation. There'd been affirmation. But so then what is then decided on this case is overturned. In the circumstance, the pulse decision does not arise. I should, however, address it in case my conclusion affirmation is wrong. Noting that MARM had originally sought rescission of the senior loan, but this plea was withdrawn, so that MARM's claims currently pleads entitled to rescind the swaps and sums paid thereafter. They then, the banks came up with the partial rescission, relied on the partial rescission, well-known partial rescission argument. You have the citation in Murad and Saj. You can't only your contract be rescinded, representative must rescind the whole contract and none of it. He cannot reject to rescind only the part represented by obtaining the advantages of the rest of it. Now, and they said, well, these are, the banks were saying these were interdependent contracts entered into and formed part of an indivisible wider bargain where a rescission of a single contract would amount to rewriting the parties' overall bargain. Mr. Saini, respective division we've got, Mr. Saini said, no, 334, they're individual freestanding agreements. This is the argument my learned firm was making yesterday, which created obligations independent from those in the senior loan. As such, there is no obstacle to rescission that cannot involve merely partial rescission.
Right.
And they then at 335, in support of their contention, the contract constitutes an inseparable part of a larger transaction, cannot be rescinded. They relied on Molestina point, and there are a couple more authorities relied on it, 335 and 336. Yeah. And what I want to go to is actually your judgment restated in Deutsche Bank and Unicef at 337. The rule against partial rescissions at 337 applies instead to bargains rather than to individual contracts. Rescission will be refused where a contract in question is part of a wider transaction, which we say this is, the components of which are commercially interdependent, which we say this is, in the sense that they were contracted each in consideration and contemplation of the other intended to be formed together, which we say this was. It's clear, therefore, that the bar on partial rescission applies not only to inseparable parts of a single contract, but also to contracts which form part of an indivisible bargain. They shouldn't be allowed to pick and choose. Going over the page at 339, Mr. Saini did not take issue with the existence of a partial rescission bar. It was his submission, as I heard yesterday, that swaps ought not to be regarded as independent, but as freestanding agreements which did not depend for their performance on the loan. That's restating that position. 340 and 341 of the passages were particularly reliant. I cannot accept these submissions. They seem to me to ignore the commercial reality that the syndicate banks would not have advanced funds under the senior loans without the swaps or equivalent interest rate hedging being entered into at the same time. And then he talks about the structural independence there, which we don't have here, but it's the first sentence there. And at 341, we expressly deals with my own friend's point. Although the swaps and senior loan could each theoretically have come into existence without the other, the commercial reality is they were entered into as part of a single transaction. Moreover, the reality is that they would never have been entered into other than as part of a single transaction, since it was clear that the banks would never, in fact, have permitted Marm to take the senior loan without having the swaps as a hedge. And what we obviously say here is that it could have been freestanding the OBN collateral contract, but it's part of a web of single transaction culminating a few days later in the syndicated loan agreements. Nor bank would not have let us enter the single finance agreement, or they would not let the syndicated loan proceed without the OBN agreement happening. So that's the swaps equivalent. That's the argument. Whether it's persuading your lordship, I hope it is, it might not at this stage, but I don't think, could your lordship say it doesn't have a chance of winning a trial?
Does this depend on whether or not you're right or wrong on agency? If, let's assume for the moment that you're wrong about the agency, then the position would be that Noor's rights would be affected, but the syndicate's rights would not.
Yes, yeah, that's right. Agency would deal so far as,
but because the two are inseparably linked, you say, from the point of view of Noor and your and the defendants. But if the syndicate has not authorised it impliedly, expressly, ostensibly,
yes,
whatever.
Yes, that makes absolute sense.
Yeah. Okay.
So that is our argument on, as you can see, on the duress points, and then similarly, in effect, on what my learned friend said, it was really what I wanted to say on the collateral contract point, which is that the duress extended effectively to both because of the side, the connections are as part of a single transaction, and they can't be treated separately. So that's I think as good as I can get on those points, my lord. I hope you understand.
Got it.
My learned friend also went on to make a point that there's no chance of showing that a collateral contract arose, such as to be incorporated.
Can I just explore that general question with you as to what, in truth, is your best case, so to speak, in relation to the characterization of what was said at the meeting on the basis of the chairman's evidence?
Yes, I was going to address that because I know your lordship was troubled about whether it was a misrepresentation or whether it was a collateral contract.
It's a question of how you characterize it, isn't it?
Yes. Well, we say it could be either, depending on one or the other, depending on how the facts emerge at trial. And your lordship shouldn't. I don't think it would be wrong to try and pin us down on one or the other at this stage. As to misrepresentation,
what
we think it's
what I have to go on, Mr.
Yes.
Have to go on, Mr. Fraser, is assuming for these purposes that I accept the chairman's evidence. Yeah. The question is, what does that actually mean as a matter of law?
Yes.
Now, so you need to have your submissions on that.
Well, you do need to have my submissions, and I'm making them. Now, misrepresentation. I think your lordship was troubled by whether it because it was a promise to do something by a certain date, whether it could be a misrepresentation at all, representation, because it wasn't one of fact, but of opinion. And your lordship,
well, it's not of opinion, is it? I mean, the only possibilities, it seems to me, and let me put this to you straight so you can give me your submissions.
Yeah.
The wording is, they said that even if the full 450 million dirhams was not arranged, they guaranteed to provide a minimum of 100 million dirhams in working capital by March 2019 at the latest.
Yeah.
It's important to emphasize this was not something they stated they would merely consider, i.e. it's not simply a question of intention that they would think about it or might do it, but something they said they would do. Now, I see that as being a promise, a guarantee. And I don't see how that is susceptible on the face of it of being a representation of fact or even a representation of state of mind.
Well, I was going to say, because it is in paragraph 161 of our skeleton, we cover the question about whether it could be a representation of a state of mind. And that is to say, does it contain an implied representation that the eighth claimant had reasonable grounds for making it?
But where's the representation is what I keep asking. I have a very simple mind, Mr. Fraser.
That's certainly not true. That's certainly not true. Well, it's in paragraph 72 of the pleading of our amended defence.
Never mind your pleading.
So what we're saying is that the representation that they would pay us 100 million by March 2019. That's the representation, the working capital statement, sort of reduced in simplicity. That's what the representation was. And we say that contained an implied representation that the eighth claimant had reasonable grounds for making it. Now, as we now know, or we think we can see, your lordship can see from the internal law documents, that it doesn't look like they had an intention of doing that. It doesn't look like they did have reasonable grounds for making that statement. And they simply said it, as it were, to get us over the line. Prima facie, if there is such an implied representation in that phrase, then we would have a pretty good case, you'd think. They say we have no prospect of, or have said we've had no prospect of establishing that as an implied representation. But I noticed it wasn't pursued in my learned friend skeleton, and in truth, it would be difficult to do that because of paragraph we have the Food Co case that your lordship will be familiar with, the Mr. Justice Lerson's, which we set out in paragraph 163 of our skeleton. And it's that passage there. It would not, I think, be difficult to say in most circumstances, a prediction about the future, particularly in the context of contractual negotiations, would necessarily be understood as implicitly representing the maker of the prediction had an honest belief in it. The existence otherwise of belief in it is a present fact at the time the prediction is uttered. If, therefore, the maker of the prediction does not have an honest belief in the prediction at the time he makes it, he would have made a false representation of fact. In other further cases, further implications may be appropriate. It may be the representation would necessarily be understood as meaning that the prediction is based on reasonable grounds.
What was the representation in that case? Or what was the statement of future intention in that case?
My lord, we'd have to go there to look at that. I'm just relying on that, be upfront on that.
Well, I'd be interested in seeing that.
Yeah, I'm very. Let's have it. I think I do now.
Do you want to come back to that later?
I might have to come back to that later if those behind me to assist with that. So. Yep. It's not explained why, on the facts of this case, the defendants have no reasonable prospects of establishing that implied representation. And you might understand why they don't want us to go there, because it does look like we could probably understand it. I mean, so in the appropriate circumstances, are we in the appropriate circumstances? A promise of future action can contain an implied statement of fact. It leads to a conclusion that would normally be difficult. It would not be difficult to say a prediction contains an implied representation. We say it would be appropriate here. The question of what is going on internally within Norbank's appetite to lend, credit approval, etc., all a black box. All the black box, no need to Norbank. In making a promise of future lending, Norbank are making implied representations about the context of what was in that box. There is no reason that the group reasonably ought to inquire beyond that curtain instead of having relied on the promise of containing those implied representations. And we lead to this this submission. The claimants can't have it both ways. They say that the working capital statement is too uncertain to be contractually binding promise, but then too akin to be a contractually binding promise to be a misrepresentation, too akin to a contractually binding promise to be a misrepresentation. So in this lacuna, they're suggesting we should dwell, and we say that would be unfair on us. And at this stage in proceedings, it must be possible that arguable there's an implied representation on the misrepresentation side on that. So that's, if you like, coming, and I'll come back to the food code case if the Lordship will let me do that before the end of my submissions. As to the collateral contract, my learned friend's point, the other side of that, if you like, was, well, it's too uncertain to be a collateral contract, to be enforceable. That's a new point. My learned friend made it yesterday. Slightly unfair, I was having to do with it now because Mr. Brooks did make 17 grounds clear their objection to it, and this is a sort of an additional ground, but I will proceed to do so. I know your Lordship is interested on. Now, that argument relies on the lack of a formal written agreement to prove lack of collateral contract. In essence, there was no written contract. There's nothing out there. How can you say it's too uncertain? The promise is too uncertain. But that takes us back, we say, to the rushed nature of things as of the 16th of December. Everything was being done in a hurry then. Both parties needed a quick deal, especially the bank, to get security before closure. So not improbable that a legally binding collateral contract will be inferred, especially as I said yesterday, the group in good faith acted on it and provided the security. The fact that Nur thereafter avoided entering the written agreement about the security, which may well have contained the 100 million, should not be held against the group. It could well have been a binding oral agreement as to principal terms, especially as the BBIH acted on it in good faith.
partially executed by both parties in effect, because we executed the mortgage with their cooperation. They've taken the mortgage and they've executed the mortgage. The rest to be negotiated in good faith. Now, what are the circumstances in which there are obviously circumstances in which parties will act without written agreements signed, sealed, and delivered, and where they go ahead and act, there's a lot of authority about whether there is or isn't a legally binding agreement. You'll also be aware of all those. We put one of those in the bundle with the Supreme Court in Monterey. Was considering a case with a different facts, where there are lots and lots of drafts, nothing had reached signed level yet, and then the workers proceeded to do the acts, and then it was then decided in effect that ultimately it was not subject to contract anymore, and they were going to question of what contract they were going to be formed under.
I'm so sorry to interrupt. I do apologise. I apologise for this. I'm afraid in my building there is a fire alarm going off. I had thought it was a test, but it appears not to be. So Mr. Watson and I are going to have to vacate. Oh, it's just gone off. I apologise for the interruption.
It is. I've nearly done 2 hours. I wouldn't mind a very short break if your lordship. I think we broke yesterday after 2 hours.
I was thinking about that sort of time, and whenever there's a convenient point to break off.
I think, my lord, that's very kind. I think now would be a good moment.
All right.
Apologies again for prompting that.
No, that's all right. All right, we'll take court for now then.
I'm grateful.
All right, thank you very much.
My lord, just before I go back to Monterey and the question of the concluded contract, you asked me a question about Foodco and the representations in Foodco.
Yeah.
Can we just go to that case? It's in case file tab 60 of our authorities bundle, and it is page 2846. It starts. And what it's about, and this gives us as good a description as any, actually, in paragraph 1, it sets out that this is about a developer, H. Boot & Co., building a development, a new facility called Stock 24 at junction 11 of the M20. And its components were a petrol filling station and an amenity building housing retail and catering units let to a number of different tenants. Their marketing material had predicted 88,000 visitors a week, and this prediction proved optimistic. They didn't reach a tenth of the number. What went wrong, and are they liable for the disaster for the tenants? A lot of them came into agreements for lease, and a lot of them gave up. They say they were tricked. In essence, the important misrepresentation of which the claim is based are alleged misrepresentation about the extent of the motorway signage that would be provided for the site, misrepresentation about the number of nightly visitors to the site, and misrepresentation about the facilities that the site would offer. Those that sign the facilities that would offer would be within the realm of what Henry Boot could do. They say they made misrepresentation fraudulent and so forth. Those actual predictions, the misrepresentations are set out a little more clearly at 2900 particulars. Paragraph 180 in the brochures, and you'll see that they're the sort of ones to bear in mind. I'd like it 2. This is more of a prediction. They represented the footfall site was circa 4.5 million visitors from opening, that they had an honest and reasonable grounds for thinking it would be that it was at this number. Brochure 1, there would be a travel booking service and tourist information centre. Brochure number 4 is they would have live depart for information. 2 and 3 that they have dwell times, and 6 and motorway signage. So these are all those are the sort of representations that the lordship was interested in. Just going forward, as we're in there, you'll see it 196, which is 2905 of the bundle. You'll see this discussion about representations about matters in the future cannot either be true or false at the moment it is made, although it was anything it's a contract or a promise, and we have that distinction. And then you have now 196, bare prediction does not attract legal consequences. A statement about the future may implicitly contain a statement about the present. You'll have to be cautious. And then that's quoting Lord Wilberforce and British Airways Board. And then at 198, we have the passage that we relied on, and I quoted in our, it would be difficult that the prediction would necessarily be understood as implicit, representing that the maker had an honest belief in it. It's the existence of otherwise is a present fact. If it does not have an honest belief, he made a false representation of fact. It may be, further implications may be appropriate. Maybe the representation would be understood as meaning that the prediction is based on reasonable grounds. And then in that case, going forward, you see actually that they did decide that the representations as to future visitors and as to whether there would be tourist information, the travel booking services, live info, departure information, and dwell times were found not just to be promises, but to implied grounds. Implicitly represented, they honestly believe those estimates. And in that case, I think they had to show fraud because it was a non-reliance clause. But there was an implicit belief that they had grounds for saying that at the time. So that's why we get that. I hope that's helpful to your lordship.
Thank you.
Going back to the question of a concluded contract, obviously, if it is partially executed, then the court is more inclined to conclude that there was a contract. And so I was in the middle of this. I don't know whether your lordship needs me to take authority for that, but the Supreme Court, in considering a much more complicated case, you don't need to see it.
No. If the issue often when you've got a partially concluded contract is, well, what was the actual terms of the contract? But
yes,
the existence of a contract can be implied sometimes from statements that have been made and then the acts that have been done. But
exactly, and in this case, acts have been done by both parties. So we've executed the mortgage, they participated in that and taken the mortgage, and due course they've executed it. So it's partially executed.
Do we actually have? I've asked this question before, but do we actually have that mortgage?
What we
I've seen this certificate of registration.
Yes, what the mortgage consisted of a lease assignment and a security executed over OBM's assets on the site leased. OBM has a lease agreement with the Free Zone Authority. In order to execute an assignment of the lease, a tripartite agreement has to be executed by the tenant company, the Free Zone, and the bank. And there is a draft of that at page 688. So I don't think we've got any of the signed documents. I can just say what this is being exhibited by in my learned friend's exhibits and Mr. Ali's exhibits. Page 688.
Yeah.
So that's the tripartite agreement. And you can see that's already being signed up by the 20th of the 12th December, for the few days of the meeting. Further, a letter was to be executed to secure the debt against all property on the leased Free Zone premises, and a paragraph at the end of the letter at page 689. So here is a draft mortgage at 689. I hereby confirm our consent at the bottom there. I confirm our consent to have the mortgage property belonging to the company which are located at the premises, whose details are set out to the mortgage or NOR bank as a security of the facilities extended to OBM Energy, standing at the date of that date at the sum of that sum. We don't have the final documents as executed, only the draft versions as attached to the email at 680, and I think there are, I've seen agreements to lease. The lease agreements are sent by
BBIH to.
Anyway, I mean, there's no doubt that it's all in favour of Noor, but you say the question is in what capacity?
Yes, exactly. And you see the notification of security interests at the over the petroleum tanks, which I think are the great value, these great holding tanks at 692.
I suspect that's as far as we can get on that.
Yes, thank you.
So can we get to the can we get as far as collateral contract? We say yes, imply these terms. We're partially executed. What more needs to be done? It's a provision of the 100 million in March. There's not more else to be done. And then if they say, well, what would be the interest and so forth under that? But there isn't any question of further security because they've got the security, the ABN security. So that's not really going to be an issue. And you expect to be able to imply terms of similar rates with their other facilities. So I don't think there's a great deal needed to be inferred to get this contract across the line, if you like. And for the lordship side, it's too far, it's too uncertain, nothing's been concluded yet. We would say that it's all but really an agreement had been reached, and if there are only I's to be dotted and T's to be crossed, then they were not of material relevance. Just the money needed to come. My learned friends, other points on collateral contract which were flagged previously are we address at paragraph 178 to 80. He's basically saying there's no chance of a collateral contract because we've got this big agreement and you can't get these statements into that on the side, if you like. And our points about that are set out at paragraph 178 of our skeleton argument. Your lordship, just read those to yourself, and I'll take the relevant authority.
Yeah. Yes.
And says that it's contrary to it can't. There's no basis of the implication, and it's contrary to the expressed terms. But we say that as a matter of law, those are wrong. It's an implied term because it's a collateral contract where a person enters into a contract on the promise of assurance of another. This can constitute a contract collateral to the terms of the main contract. And this is fairly trite, but this is particularly so where one party refuses to enter a contract without the particular assurance being granted. On this front, we get the working capital. That's what we'll go into it. There's nothing in the terms of the syndicate facility agreement that would preclude a collateral contract arising because there's no general entire agreement clause, and I think that's not controversial.
Now, are you? I'm sorry, just to be precise. Is your case that it's simply a collateral contract or a misrepresentation, and that there is no implied term as such? Or
well,
I think we're maintaining the implied term case.
We're maintaining the implied term case. It's paragraph 87 of our defence.
Well, I appreciate that, but I wasn't sure whether paragraph 179 of your skeleton was abandoning it.
Well, I mean, we're seeking it as a term of the contract between the parties contained outside the contract, but is to be enforceable against all the parties. Your lordship, you would characterise that as in here as an implied term, but your lordship, it could be characterised as a collateral contract outside it. So be it. But I think our analysis of it's implied into the overall contractual terms between the parties, and that's the sense we mean it. So just thinking of the Think group, for example, that case, which is at tab 65 of the case file, page 3115, looking at paragraph 83. which is at 3146. They say, well, it can't exist because it's be inconsistent with the written terms. Sorry, I've given myself a wrong reference. I will get there in a minute. The point here in the Court of Appeal, acknowledging in paragraph 83, is despite the length of things Scalia's argument on this point, Mr. Keeley's submissions on it were relatively brief. He accepted that the doctrine of collateral warranty could give effect to such a warranty as to enable it to take precedence over the inconsistent wording of even a signed contract. And they say he was right to do so, on the basis of the effect of collateral warranties to misrepresent the primary contract. Going over the page, there are many cases in the books where a man is made by word of mouth a promise or representation of fact on which the other party acts by entering into the contract. In all such cases, the man is not allowed to repudiate the representation by reference to the principal condition. The reason is because the oral promise or representation has a decisive influence on the transaction. This is the very thing that induces the other contract. It would be most unjust to allow the maker to go back with it. Printed condition is rejected because it's repugnant to the express oral promise. So that's why, my learned friends, when it's inconsistent with the terms of the contract, we say, well, that's precisely the grounds on which you could find the collateral contract is existing. Yes. I mean, obviously, it's a question of these are questions of fact of whether we could show the collateral contract existed for them to provide the money, which causes us to enter into all the agreements, fact sensitive. My learned friend relied on, for example, Mr. Justice Lightman's judgment, entrepreneur. We say that doesn't save him, as the learned judge kept on emphasising this is all a matter of fact, which needs to be looked at as part of the totality of the evidence. And that's the reference to that is 1859 of the bundle. Mr. Justice Lightman was on some of the conditions about that, which we'll see it. We could just pick that up. Entrepreneur. No. 1859.
Yeah.
The relevant legal principles regarding the recognition of those promises only be true as having contractual effect. The evidence shows the parties intended this to be the case. Intention is a question of fact to be decided by looking at the totality of the evidence. The test is the ordinary objective test in formation of a contract. What is relevant is not the subjective thought of one party, a reasonable observer. Whether it's followed by further negotiations in a written contract not containing any term corresponding to the statement. In such a case, it would be harder to infer the statement was intended to have contractual effect, with the assumption that the written contract would include all the terms. But of course, there wasn't an entire agreement clause in our current case. There isn't one. And we have seen in the Think judgment, the Court of Appeal saying it's right that oral promises can have precedence over the written matters if it was sort of central to the tension of taking part. And thirdly, fourth, important factor will be the lapse of time between the statement and the making of the formal contract. And of course, as your lordship has seen, it was a very, very limited lapse of time between the 16th of December representations and the contract being entered into on the, I think it's 27th of December, and all the matters being done in the meantime. So my learned friend raises a point about whether the court should be reluctant to imply a term into the contract which can be assigned on the secondary market. Any person, in this respect, we submit that any person who takes an assignment of an interest under the investment agency agreement or the conventional facility agreement does so expressly with no representation from the existing lenders that the finance documents as a whole are valid or effective unless expressly agreed to the contrary, as such that they agree to take the assignment at risk of invalidity. And you see that in the bundle in clauses 13.4.1 of the conventional facility and 6.4.1 of the investment agency agreement. Does your lordship want to see those?
Perhaps you better look at them.
Now, 729 is the first. 13.4.1, that's the conventional facility agreement. Unless expressly agreed to contract, existing member makes no representation, warranty, and assumes no responsibility for the validity, effectiveness, adequacy, enforceability of the conventional finance documents, and so forth, the finance position of the company. So anyone who's taking assignment of these is knowing, gets this with these disclaimers, if you like. And at 796, ditto. Oh my goodness, crazy. Sorry, my mind. Okay, 796, I think, likewise under the investment agency agreement. 6.4.1 is likewise there. Next in order, I was taken slightly out of my path by I know your lordship's questions about misrepresentation, but my learned friend, having dealt with collateral contract, then turned to the question about no reasonable reliance. We weren't entitled to rely on the misrepresentation. Lordship recalls that. Now, that's again a new point. It wasn't something flagged in the application notice or Mr. Brooks's witness statement as one of the 17 grounds. So it's yet another ground. I think we see it at paragraph 101 of my learned friend's skeleton. The underlying principle of the document misrepresentation is that the contract statement must be one in which the party to whom it was made must be entitled to rely. Bailey and Barclays Bank. These have no prospect of showing they're entitled to rely on an informal statement allegedly made at the PAR meeting. Banks do not make offers to lend, this is 102, do not make offers to lend informally. Certainly not offers to lend such substantial sums. Defendants do not allege there have been any discussions as to the terms and sums in which the Nor Bank would provide working capital. We say that's all material matters understood. They must have understood at the PAR meeting any proposal was subject to further negotiation, detailed terms. Any reasonable person in the position of those would have known that there was a concrete written offer. They could not rely on any statements. And then they make the point about the vagueness. Doing as best we can on that at this today. Yes, we accept the legal principle at 101 that in due course we'd need to show there's a question about implied entitlement to rely. But I don't think they've shown that we have no real prospect of establishing entitlement to rely. It's all a matter of fact. And we say it was reasonable here to rely on those statements. It was clearly, your lordship, seen from the timeline of the 13th of December email, it was clearly in the middle of a very rushed phase. Everyone wanted this agreement, syndicate finance agreement, closed. They were hoping to have it closed by the 20th on the 13th, and in due course had it closed on the 27th. So time was very much of the essence. It needed to be closed quickly. Nor wanted the security quickly, and indeed your lordship has seen within a matter of days they're getting hold of documents, asking for documents, getting them, and coming up with agreements as regards just simply getting hold of the security so that the syndicate finance loan can go ahead. Is it unreasonable then for the chairman in these circumstances, who deals, he says, on handshakes and agreements between him and bigwigs, for him to rely on that word that the at least 100 million were coming. And the fact is, the reason was he is he enabled it to happen very quickly. He supplied the security without the agreement in good faith. So he must be as good an arbiter as any of what was reasonable in his mind. It was reasonable to rely on that in the overall circumstances. Don't forget, he was told by Mr. and Ian and your lordship could see that evidence again, remind the lordship that evidence again. Paragraph 41, really, of the bundle at 1322. The Royal Bank's representative responded by asking me why I was looking to other banks to raise working capital when I could look to them and the syndicate instead. Royal Bank's representatives explained this to me as follows. The syndicate banks were closing one of the biggest deals in the market, and Royal Bank would be a substantial participant. They needed us to succeed for them to succeed. And this was a collaborative relationship. In those circumstances, why would the syndicate banks not give us the working capital? Why would the banks close the deal without lending money to keep things going? They're going to do it. That's what he's being told. And then he's told the specifics. And those promises we've covered in 43. 44 specifically addresses my learned friend's point. He claims I should have understood that he could not provide working capital without further internal sign-off. I do not accept that as fair. I was at a meeting with a group of senior employees. When you have bank bigwigs sitting in front of you saying they will give you money if you do certain things, you sooner know that they were talking about and believe they have the authority to do the deal. I certainly believe they do. Banking is their expertise. And they finalised there was no reason not to believe them, and he thought they're ethical. So I don't think at this stage to decide, well, it's not reasonable for you to rely on that, is an attractive submission. As we say, it's how the chairman did business. He assumed that if there were any outstanding terms, they'd be dealt with in due course. Finally, on that point, we don't accept that, quote unquote, at least 100 million is too uncertain. 100 million is a minimum. That's provided they've complied. It's not difficult to understand. There wouldn't be any question about that. So is that too vague? We would submit not. So I think we address that point. Then there's the question of actual reliance. Well, are we going to be able to show at trial that we actually relied if we were because we would enter the contract anyway? Well, the chairman's evidence is that actually he would have needed to keep the OBN unsecured to obtain working capital elsewhere in order to make the syndicated loan work. That was the point. The syndicated loan could not work without the OBN being used to get working capital. And his evidence, he says that I was looking elsewhere to make it work, and I would have needed to kept it out, but I was persuaded to put it in. So it can't be said that he would have gone into there with the OBN security, because he just wouldn't have done. He would have kept it outside to raise capital elsewhere. And so I think we can show reliance in that, well, at least arguably at this stage, and the lordship, these facts will come out in front of a trial judge in due course. So that brings me to the question of Sharia. Now, we addressed this at page 199 of our skeleton. Now, the first point, and I think it's a point worth bearing in mind for lordship, is that if my learned friend does not succeed in booting out our defences on duress, misrepresentation, breach of contract, then it will be a bit of a waste of time going into the Sharia issues, because Sharia, then the purported agreement, will be subject to the defendant's counterclaim at trial and will be going into. So they can't win today by just defeating these Sharia defences. My learned friends, oh, well, this could be a sort of save time at trial, but it's quite a big issue then to say, okay, well, we'll now go and decide all the points. We don't need to do that. So that I think that's an important point for lordship to consider, particularly as I then go on to make, as even looking at the Sharia points, is involving a mini trial of its own in a factual vacuum without much worse in this case, without expert evidence. And that's the point that we go on to make in paragraph 200, which is the grounds in which they seek immediate judgment all relate to the claim that the purported Master Murabha agreement is a nullity, as it does not comply with principles of the Aofi principles of Sharia. Forgive me if I mispronounced Aofi. The point is that these principles are an interpretation of how Islamic law and traditions should be followed in relation to finance transactions. They may appear unusual for common law trained practitioners and different policy priorities for those English law, but compliance with them is a matter of significant religious importance for many of those of the Islamic faith. So perhaps for this reason, while it was made clear by the Court of Appeal in Fidel and Felicia, the IFC court judges, such as yourselves, are allowed to make findings on matters of any applicable system of governing law without reference to expert evidence, and that was in 2015. An exception exists for matters of Sharia. And that is because after Fidel, not before it, overridden by the Court of Appeal, but as a consequence, it is to be inferred of Fidel, or at least post-crop, the registrar's direction comes into effect or is issued, and Lordship will see that at tab case file 82. It's 4161. November the 15th, 2017, subject matter expert evidence of Sharia law comes into effect on signature. Pursuant to the rules of the District Court, the giving of expert evidence is regulated in the manner prescribed by Part 31, and in the background expresses how they can give their opinion and advice on any matter concerning a trust if it makes 6 orders concerning it. And matters where Sharia might come up. And then the direction is where the requirements of Sharia law are relevant to a matter before the District Courts, there are to be established as a matter of expert. These are to be established as a matter of expert evidence. And Article 1 applies to the parties who seek to place such evidence before the court in any particular hearing. So where the requirements of Sharia law are relevant to a matter before the District Court, there has to be expert evidence. There is no expert evidence filed by my learned friend on Sharia law. They've made an application to reduce expert evidence. My learned friend is a very eloquent advocate on the subject and is obviously well practiced in it, but he's not an expert, and there has been no application for expert evidence. So we say on those grounds alone, my submissions, my learned friend's submissions about compliance, what they were, grounds 15 and 16 in Brooks 4 must fail, really, and we're not going to be entertained. We're not going to be making submissions on them because that's for expert evidence. As for the other grounds, well, the expert, such as whether it's been incorporated.
Forgive me, Mr. Fraser, for my ignorance and idiot boy questions, but am I bound by registrar's directions?
Well, I think wouldn't there be a system of slight chaos if it was to be ignored?
I don't know. I mean, are they the same impact as rules of court?
But I think so. Yes, that's my understanding. That's our submission. And your lordship wouldn't want to disobey an English rule of court any more than you would a DIFC rule of court, or vice versa. Put it that way. That's a rule of court. I mean, it couldn't be expressed more plainly and seriously. So that's our submission.
Yes.
And so if the, and it also means that
I certainly wouldn't want to decide a dispute on Sharia law without.
Well, put it that way. Certainly not on a summary basis. So it's, and also the other points, like whether it's been incorporated into the contract, we say, well, the absence of Sharia evidence might not mean these grounds necessarily fail. You're obviously going to be slightly hesitant before determining even these points on a summary basis in the expert evidence, which will be available of trial on the question of what the Sharia means and whether there was compliance or not. That's going to be at trial. Would you be wanting to discuss be deciding other matters in advance of that? with that in a vacuum. We suggest that would inform the status. And so we would suggest really for two grounds. One, as I say, if your lordship is with us on the other points, then we don't need to go to Sharia law. Or two, if the absence of expert evidence really is fatal, not just to the sort of the two obvious grounds, but in fact to all of the grounds, and one shouldn't really go there. So those are the general points. I think my learned friend's really main point, what he majored on yesterday, was his submission that we had no prospect of showing that the standards, the relevant regulatory standards, were incorporated into the facility, into the Sharia facility. And what we say about that is really covered in paragraphs 216 to 222 of our skeleton. I'll take your lordship through that. But the overall point is that it's really a matter of construction, chart work construction against the background facts. And there is enough here for your lordship to see that you could see that it would be incorporated, we suggest. It's certainly at this stage enough to get us through the summary hurdle. And an overall background of the facts will tell us more. So looking at 216, the well-known Chartbrook test, the terms of the contract, because it's a matter of construction at this point. Are they to be construed as incorporating the standards? The terms of a contract are to be, I think it's are rather than as, to be interpreted with regards to, and there's the quote, what a reasonable person, having all the background knowledge which would have been available to the parties, would have understood them to be using the language in the contract to mean. And that must be a matter for facts investigators at trial to really know, to get a proper answer to that. Any words in a contract which show an agreement to do a thing amount to an obligation. That's an obligation set out in the recitals to a contract, does not deprive it of binding effect. And that's a point. I'll come to that. But my learned friends say, well, the Sharia part of the contract is only in a recital, and and we say actually on HTV Limited and ITV2, where the wording recital manifests a clear intention that the parties should do certain acts, the court may infer from that wording a covenant to do those acts. So it can be part of the main contract.
Yeah. Well, it all depends on the word recital, doesn't it?
It does depend on the word recital, and when we say that where the contract states that it is governed by, operates in accordance to a set of regulatory rules, this may constitute an express incorporation of regulatory rules, and that's target. And my learned friend made a lot about target and said we misrepresented, but actually we haven't. We would submit. We will come on to why it, in this respect, is that in essence the phrasing is that the matters shall be under the Islamic facility, which your lordship will find at page 750. This is a recital, but we say it's sufficient, at least at this stage, to count as an obligation. Under the Islamic facility, the investment agent will purchase commodities and sell them to the purchaser at a cost price, together with a profit element on a deferred payment basis, with title pass and means purchaser, all in accordance with the Sharia. Now, we say that is synonymous, indeed, as we put in our skeleton, with governed by. In accordance with, governed by, are they really any different? My learned friend said, oh, yes, target rich is all about, says if it's governed by, that incorporates it, but we have nothing like that here. But we do have something like that here. We have in accordance with the Sharia. And the second point is that, of course, it then, under what Sharia is defined, it says, it's not just a single phrase. Over op 754, the definition Sharia means the rules, principles, and parameters of Islamic law. So it's not just a phrase, it's a reference to rules, principles, and parameters. And what does that mean? What are the rules? Is this particular contract incorporating? And it's what that means, what the factual matrix for that behind that, what the parties intend to mean now, that is going to be the key question. And that we don't think your lordship can decide today. There are good arguments we set out at 222. Little one of our skeleton, that it should be the standards, because the master Murabba was entered into in onshore UAE with a licensed financial institution regulated by the central bank. We say that the rules, principles, and parameters of Islamic law in such a context would reasonably be understood as a meaning of such rules, principles, and parameters as applicable in the onshore UAE in the financial context, rather than, say, the whole body of Islamic laws regards matters as divorce or halal food. We go on to say that 2, the UAE had in 2008 enacted various pieces of legislation increasing the level of regulation as to matters of Sharia compliance. The establishment of the high Sharia authority, the resolution itself, the authority resolved that the standards be binding on financial institutions from 1st of September 2018 onwards. Indeed, shortly before this contract, and the definition of Sharia differs in the bridge facility. That's the one earlier in the summer. Rules, principles, parameters of law as interpreted by the Supervisory Committee of the Investment Agency. And now, a little later on, there doesn't seem to be a need to include that, or it's developed as a matter of external matters, because there isn't a reference to that now. Now it's the rules and parameters. And we say, arguably, that means because of the introduction of the standards, that would be what it meant. So we think that reasonable persons in the position of the parties to the agreement in December 27, 2008 would understand these rules, to reference to rules, principles, and parameters as to meet those standards, and such standards being the mandatory interpretation by which all Islamic facility institutions regulated by the standards were required to apply. My learned friend, and I could take you back to Target, but I think your lordship, if you like, but it was the distinction there about whether it was governed by or not governed by. Your lordship wants to go back to see. My submission is in accordance with, it's synonymous with governed by. Right. And so my learned friend's points yesterday weren't we would submit overwhelming, shouldn't overwhelm your lordship on this point at this stage. I think 2 material points he made, one of which he said there was a logical flaw that militated against the incorporation of the standards into the master, because as a matter of objective intention, the flaw is that it means if we're right, that the master agreement is a nullity, which the parties cannot have intended. But we say that's a hindsight argument. At the time, and this is, we go back to the argument, go back to what the parties thought at the time they thought they complied. We know that because at 750, recital D, each party has independently reviewed the Islamic finance doctrines for the purpose of ensuring their compliance with the Sharia and is satisfied that they do so comply. So you can't say, oh, well, it can't have been their intention to include the standards because they knew they didn't comply. On the contrary, what your lordship has been told that they thought they did comply. Whether they did or didn't comply would be a matter for investigation at trial. So we don't think the logical flaw exists. My learned friends also made the point, oh, well, a new point, but we'll address it, that the grace period, there was a grace period under the resolution that meant that the products being, the products had a 2-year period, existing products as of the 1st of September 2018 had a existing period, 2-year period, I think, of grace until 2020 for a time plan. And it's at the page number is 4206, my learned friend, the lordship probably recalls it. But it says that the products, activities and services adopted and currently used by the IFIs prior to this resolution should be revised in accordance with the standards based on a time plan should not exceed by the end of December. Well, that might be right for products which existed before, standalone off-the-shelf products, but there's no evidence to suggest that this was a product which existed. This particular facility looks like a bespoke facility that was agreed after the 1st of September. So on the face of it, it looks as though the standards were applicable to it. And so we would say that is the answer to that. My learned friend did also seek to rely on various contractual non-reliance clauses or waivers, which they said should preclude us from challenging the MRAPA on grounds of non-compliance. And we address that at paragraph 229 of our skeleton. We say they set out various non-compliance clauses or waivers which they claim to allege give rise to a contractual estoppel, precluding the defendants from challenging the MRATA. Our essential point is that no estoppel arises from these clauses, or arguably doesn't arise, because they appear to be contrary to public policy. And it can be an argument, and we set them out at 230 in Springwell and in Palmer, that if contractual estoppel is enforceable, except insofar as the agreement contradicts some other specific, more general rule of English public policy. And in Palmer, the court stated it would have held a non-reliance clause void for being contrary to the FCA handbook. Our argument is, whether it's right or wrong, is that the same principle could apply by analogy in this place. We say it would contradict public policy to enforce non-reliance and waiver clauses that run contrary to the UAE financial services regulations. They're not English, so what in this case? If it's against public policy in the in UAE, and these resolutions have just been brought into effect, is it really right to say that the parties can contract out of them if there is authority to suggest that public policy would militate against a contract being enforced in that way? So in that respect, we make the argument we do at 231, even if they were stopped, it wouldn't mean that they were stopped from complaining. The underlying would be a nullity. So we feel that there's an argument there that these clauses could not be relied on for public policy purposes, and it wouldn't be safe to come to that point until we've had expert evidence on the meaning of these clauses under Sharia. So
what's the basis for saying a nullity, that a breach of the Sharia makes the whole thing a nullity in any event, leaving aside for the moment the waiver clause?
Yes. Well, it's at 227 of our skeleton.
Yes. Well, you say we simply don't know.
We simply don't know. We don't know what Sharia law requires as a consequence to the failure, and that is bound to want to be taken into account by a trial judge as to the impact, as to whether it makes them requires to be a nullity. To the extent that the questions of nullity are a matter of English law, we should be hesitant while requiring them not knowing what Sharia law requires. And of course, there's the point at 2273 is that clause 4E of the Murabha master facility, which is an alternative answer on the issue of nullity and contractual estoppel. And that's what it set out. The investment agent shall only enter a Murabha contract if it is not illegal or unlawful for the investment agent to enter it. In the circumstances where the contracts do not comply with the standards, we say it would be unlawful for the investment agent to enter into.
But I understand you say that. Where's the evidence of that? I mean, one's troubled by the idea that on a summary judgment application, you can simply plead something and say it's a nullity and then not produce any evidence in support. I appreciate there's no evidence of the claimant, but there's none from the defendant as to Sharia law either.
But we don't have the burden.
Well, I understand that, but does it
Well,
mean that if you simply assert it, it's good enough?
No, but if my learned friend had wanted to overcome that assertion and pleading, if they wanted to overcome that, they would have put it. They could have put in expert evidence, say actually none of this, it's not a nullity under Sharia law, and if it's plain and simple, then it's done. But that, I think your lordship's putting the burden on us when it shouldn't actually be on us in that respect. That's my answer on that. And so I think exactly on the 4.5 hours, those are my submissions.
Right. Okay. Thank you very much. Yes, Mr. Montague-Smith.
Thank you, my lord. First, I just wanted to make a few short points on the facts themselves, the factual issue. And I just put it like this. I'm going to go through it broadly in the same order as my learned friends, because that reflects the order of my notes. That may be slightly disorganized, but hopefully it'll engender some discussion and I can actually meet the points that are troubling your lordship as we go, but obviously do make the points. First of all,
you know me, Mr. Montague-Smith, I'm not slow in asking questions ordinarily.
I do. So I am anticipating that, but I shall bang on until you interject. One of the first things that my learned friend said in his submissions was he made this factual forensic point. He said, well, it must have been the case that working capital was raised at the meeting in December, and he uses that to build an edifice, which leads to him saying, well, now you have to doubt Mr. Ali's evidence. Now, I accept this is not necessarily the forum for the usual trial process, and I rely on those dicta that you don't need to take at face value simple assertions by individual witnesses, particularly where they're contradicted by evidence. But just dealing with this sort of logical point that he makes, he says, oh, well, it must have been the case because, and he says, this was the last chance for the group to get working capital. That was the way he put it. And I just make the point that that is flatly inconsistent with his own documents produced the day before yesterday, because we have seen in that recent disclosure that the group was going around on a bilateral basis with the majority of the syndicate and then approached the syndicate as a whole for working capital and was offering up collateral in support of that independently. Because obviously, if it's going to the syndicate, it might be able to persuade the syndicate to lend more on the basis of the existing collateral. But if it's going to banks on a bilateral basis, it's going to have to produce more security. And that was the point, the problem, the mistake that it undertook. But in any event, and indeed in May of 2019, you've seen the minutes of the meeting where it got an agreement in principle from the syndicate to lend working capital, albeit one that is subject to an equity injection. In relation to that, my learned friend said there's no evidence as to whether that equity injection was provided. In fact, there is evidence in relation to that in Mr. Ali's statement at paragraph 125. That's on page B, tab 8, page 141, where he makes that statement. So it is not right to say that your lordship can find or can consider that there's even a real prospect that the meeting in December was the last opportunity for the group to get working capital. That is just wholly contradicted by everything that came after. But this emphasises a curious problem in the case, because my learned friend's case is that they were promised working capital, and they don't say on what terms. And unless they are saying, it may be that in fact, I heard my learned friend said, in effect, what he is now saying is that the group was promised unsecured working capital. So in other words,
no, he's saying that the security had already been provided, because he says the deal was the OBN security would be security for the working capital. least that's how I understand it to be.
Well, he may have said that in submissions. That's not his pleaded case. The OBN security, he said, was demanded in order to secure the lending as a side agreement, the lending under the facility. So he has to say that then there was a further agreement to provide working capital for which no further security was going to be provided. So to that extent, it is unsecured. And of course, there's other security out there because Noor is participating in the facility. In his submissions, there's this repeated, and he continues with it, my learned friend continues with it, suggestion that there might have been side promises along the way in the run-up to the December meeting. Precisely what is said to have been promised is not explained. And at that point, presumably, there was no discussion about security, or we don't know. But my learned friend says, well, it's a reasonable possibility. He doesn't go so far as to say it's a probability at this stage, but he says a reasonable possibility that some of these side promises were made. Now, one just has to realise the import of those sorts of statements, given what we've seen about the documents behind the scenes about what was approved and what could be approved and what the plan was for Noor, which was to reduce the exposure. And so a statement which said, we will give you working capital over and above, my learned friend actually confesses to it in his skeleton argument. He says, ultimately, it's difficult to see how this wouldn't end up being a claim of dishonest misrepresentation, a claim in fraud. He does use the word dishonesty as well. So one has to see the probability of those sorts of statements, assess the likelihood of that being established at trial on the basis of the sorts of things that my learned friend is saying. It's an allegation of fraud. Now, in this context, he put a lot of weight on the exchange at page 628 of the bundle, which is the sorted email, if I can call it that. It's just worth turning that back up, just to see actually what that email says. It's behind tab B9. So, and it's in the middle of the page, the first one. This is again from Mr. Ejaz, and that's significant, and I'll come back to that. But it's to Mr. Khan, saying, kindly also update us regarding working capital facility mechanism. It must, otherwise the whole syndication effort will go useless. So there's two important things to note about this. The first, this is talking about the mechanism. It's not talking about the actual provision of working capital. What was meant by mechanism? Now, I pointed out in my submissions that there are, and it's been touched on again, there are obviously, as one would expect, controls in the facility over further borrowing that the group is entitled to obtain. That had to be built into the facility. And there was a range of views in the documents, and I've shown you these documents, but I'll show them again very briefly, about where the limits should be drawn, how the limits should be drawn. So if you go forward in the bundle to page 643, and you've seen this, showed you this particular provision, but just to remind you of it, this is the commitment letter from Nbd Bank.
Yeah.
So the fourth bullet point was the one that I showed your lordship, because that was the one my learned friend relied on. It says assignment of cash flows. This was a condition being imposed by Nbd. Assignment of cash flows should be 100%, and syndicate may agree to release a part for any bilateral working capital facilities. No further borrowing allowed without syndicate approval. So that is the suggestion from Nbd. No further borrowing, and everything is under the control of the syndicate. The other proposal that you were shown was the National Bank of Fujairah one, which is on page 647, which suggested at paragraph 12 of that the working capital cap, funded and non-funded, should be at 500 million dirhams. So there was a range of views from the participating banks, or the proposed participating banks at this stage. And as you were shown in the documents in the Common Terms Agreement, that the landing was 350 million dirham. That's on page 948 of the bundle. There's another reference on 907. So the point is that the mere reference to working capital, and particularly the reference to the mechanism for working capital, is not indicative of any discussions between Noor and the group that Noor was agreeing to provide that working capital. There were discussions to be had about the parameters within which the group was entitled to get working capital. My learned friend said the landing point for all of that, 350 million dirham, he said, well, that's consistent with what the chairman says about the meeting, because in the meeting, the chairman says that Noor agreed to go off and get 450, perhaps 350 million dirham from the syndicate. But that is not the effect of the 350 million limit in the Common Terms Agreement. 350 million is the limit of the total working capital that the group is entitled to. And we know, of course, that there were existing outstanding working capital commitments in the background. So it's 350 million doesn't mean another 350 million. Doesn't mean anything like it. It is totally inconsistent with the suggestion that 11 days before there was some commitment by Noor to go off and get even try to get 350 million. The second point on this document.
Before you go there, paragraph 12 of the NBS email. So working capital cap, funded and non-funded. Does that mean as funded by, well, who's it mean funded by and non-funded?
I think funded and non-funded, as I understand it, and I may be talking out of school here, but as I understand it, simply means what the limits are and what the existing exposure is. So it's funded and non-funded.
I see that which has already been provided as compared with that which is available. Yeah,
that's my reading of that. But obviously the result was much lower than National Bank of Fujairah was prepared to agree.
Yeah. No.
The other point I was just going to make about the document 628 is that let's get this sorted email. That is an exchange between Mr. Khan on one hand, and Mr. Ijaz on the other. And Mr. Ijaz is the one who said in that email in March 2019, we overlooked working capital. He is the individual who, fairly short time later, 6 months later, actually, it is saying, no, we forgot to deal with this. Now, in relation to some of the other documentation, there's this argument, you'll recall, that the January exchanges about the side letters are somehow consistent with promises having been made. You want to ask a question?
I do, yes.
Yes.
It arose out of a document we looked at this morning that I don't think I'd focused on before.
Is this the new evidence, perhaps the email at 4610 versus the letter?
No. Got 1347. This is Mr. Vig to the chairman, copied to Mr. Mustafa.
Yes, I see it.
26th November, talking about the terms of the documents. We found solution around the security and the legal structure. So what does that refer to?
I don't know the answer to that. Is the answer. Clearly, as I've said, there were discussions going on about what the banks were willing to participate, the terms on which the banks were willing to participate. I don't know what that particular document is referring to. But it comes before this meeting.
Yeah, I appreciate that.
It doesn't appear to be concerned with the OBN. Maybe it is. I don't know. But I don't put any weight on it as being some sort of confirmation of that at this stage. I mean, I think that is something that's too forensic for today.
Yeah. All right. Thank you.
Thank you. So I was just going to come on to the other parts of my learned friend submissions in relation to the documents that come immediately after the meeting, just so we can see what's going on at the meeting. And you'll recall the argument that in relation to the exchanges about the side agreements, my learned friend says, well, you can draw a line from that to January, and you can see the changes in January, or the competing drafts of the side agreements in January, and those are consistent, he says, with his case. You'll recall that this was about the circumstances in which some of the security would be released, and in particular, the side agreements dealt with the release of one Gulfer security when further cash injection came in, but for our purposes, importantly, the release of the OBN security. You'll have seen the email exchanges said what we agreed was 250 million, but then a side agreement comes in January, drafted by the group, which says 350 million. And my learned friend says, oh, well, that's 100 million. So that's supportive of his position that perhaps there was some commitment by Noor for an additional 100 million dirhams worth of lending. So it's just worth thinking that through. And to do that, we just look at page 1053. So I won't repeat the points I made yesterday, which is that the cover emails in relation to this, when you look at 1051, for example, says we had agreed. But in any event, when it comes back from Noor, what's happening is that the defendants are proposing, in effect, a different threshold. The threshold should be 350 million, not 250 million. And so what my learned friend is saying was that's consistent with the defendant's case. But it isn't. It's inconsistent with the defendant's case. Now, it might have been consistent with a different case if the case was that Noor had agreed to provide working capital, but only once it sold down its syndication participation to 250 million, then that might be consistent. But that's not the defendant's case. Here it's saying, well, actually, we're going to release this security when we get down to 350 million. And it's not enough, and it's a constant refrain in my learned friend submissions. This is consistent. It's not enough that it's consistent, in particular in relation to these alleged side promises. And the other refrain of my learned friend submissions is that that's effectively, he says, something might turn up. Something might turn up on document disclosure, something might turn up on cross-examination. That is never a realistic basis for resisting this sort of application. But one has to just ask, where would that investigation lead? So think about these side promises that might have happened. My learned friend's not in a position to make the allegation that they did happen, so it's not going to be an issue in the claim. These are allegations, as we've seen, of side promises which were deliberately kept out of the correspondence, even the internal correspondence. So there aren't going to be any documents that show up anyway, because this whole point is these are all side promises. What that comes to is effectively running the proceedings in the hope that you can fish something out of a witness at trial and cross-examination, treating the trial as an inquiry of the facts, not, as it should be, a determination of the issues between the parties. But then, in relation to all of this, one has to ask, where does any of this go? Because I just draw your attention back to Mr. Al-Maheri's witness statement. At paragraph 34, you'll find it on page 1321. He gives evidence about what his approach was to the meeting. And he says he was skeptical about getting working capital from the syndicate. That's the end of the third line. And then he said, what was once a good relationship with Nubank had deteriorated, and I thought we would face a better prospect of getting working capital secured against OBN bilaterally. So, and so as I read that, his evidence is that he was not at that point anticipating getting working capital from Nubank. So he goes into the meeting without any expectation, which could be supported by any of these alleged side promises. And the side promises, of course, are proposed or speculated on to support the view that perhaps that's what happened at the meeting. As I read what the chairman's saying, is that the relationship was deteriorated and he didn't think he was going to get anything out of Nubank. And if that's right, if that's really what he's saying, then all this stuff about his expectations and the increasing expectations in the run-up is just falls away. It's not relevant. And really what matters is, can the assertion in paragraph 43 of his witness statement, do you just have to take that at face value? And I won't go back through all of the correspondence that I showed you, which I say just records what the parties understood to be the deal. And that is in itself a collateral deal, a deal collateral to the actual facility. And so none of this, I say, answers that correspondence. None of it explains the subsequent documents in which it said it's overlooked. It was a mistake. Because if the reality was that something had been agreed, but just that agreement hadn't been fulfilled, then it hasn't been overlooked. There's no mistake. And in particular, my learned friend just simply did not deal with the inter-parties correspondence at page 700, which records the agreement. And my learned friend says, well, this is all a mini trial. You can't decide it. But it's worth just recalling that this is not just about whether you believe the chairman's evidence that certain things were said. It's about which part, in addition, it's about which parts of that discussion that was had in that meeting orally, objectively understood, were intended to have contractual effect. And I've shown you the authorities which suggest that you can see which parts of a discussion are intended to have contractual effect when they record their agreement in writing afterwards. As I say, so what the assertion here really is not just a collateral agreement, but it's a collateral agreement which is collateral to the collateral agreement. So the point is not just that these are alleged promises which weren't recorded anywhere. It's that there was an agreement that was recorded. So if you accept as the premise, which is that there was a binding side deal at this meeting, as I say, the next question is which parts of the discussion were part of that deal, and the answer is very clear when you see what was written down. Lord, in relation to the questions of agency, my learned friend says, well, it's possible that there's actual ostensible authority to negotiate. And then he tells us orally what are the facts on which he relies. And the fact that he relies on, he also refers to usual authority. And just to deal with that, usual authority is a form that can be used to describe both a form of actual and a form of ostensible authority. The usual authority arises from the appointment of someone or a body to a role, a particular role that carries with it that sort of authority. So if I, as a company, appoint someone to the position of managing director, then that person has the usual authority. And then you get to the point about if there are internal controls on that which aren't disclosed, then that can't confine their usual authority and all the rest of it. But that has to depend on a party being appointed to a role, which there's no allegation that the bank's appointed Noor Bank to any role. There's no case, there's certainly no evidence. So what are the facts that are alleged? The first fact is that Noor was the arranger of the facility. And it said, well, on the basis of that, it was put into a position where it could have been acting in a way such that it was agent for the banks. But the result of that is then it is acting as agent for both sides of a transaction, because it clearly is the whole point of appointing an arranging bank is that that is the bank that goes out into the market and negotiates for the borrower with the banks. And my learned friend pointed your lordship, to a particular provision of the IMLA agreement, but I think your lordship's eyes spotted that the exclusion that your attention was drawn to was of any fiduciary relationship or any advisory relationship. Clearly, it's not excluding or ruling out any agency relationship, because that's the whole purpose of the appointment. And I showed you the law, which demonstrates what are the usual expectations of a party who is acting as an arranging bank. Then it's not that they're acting for the borrowers, the lenders, it's acting for the borrowers. So, of course, when I, as a borrower, appoint an agent to go into the market, that agent will then be talking both to me and to the other side. The fact that they're in the middle of the deal does not in any way support the proposition that they're agent for the other side of the deal. If I'm the lender and I go to someone's agent and I say something to that agent in the expectation that what I say is going to be passed on, then obviously I'm going to be responsible for what they say. But that's not this case, because I've then given them that information. I've simply communicated indirectly with the other party to the deal. Here, I'm saying that the position, as I understand it, the case is that could be that I am saying something to the agent and the agent is saying something different or something extra to their principal. That's the case that's being alleged here. There's some sort of side deal going on between the arranging bank and the borrower, but that's between them. There's no way that you can get to the proposition that the arranging bank is somehow acting for the banks. Now, it was said that in relation to this particular demand for additional security, that Noor Bank, all depends on what capacity Noor Bank was acting when it took that mortgage. Implicit in that submission was that Noor Bank actually was appointed as the security agent. That is not true. It's just not the fact. Noor Bank was never the security agent. It was anticipated in the IMLA letter that they would take that appointment. They did not take that appointment. Nbd was the security agent, and you can see that from the transaction documents, page 831, paragraph clause 9, and page 887, clause 11. So all of that sort of, it depends on what position. And by the way, all of those documents were in play, as you've seen, back in November, before this meeting. So by the meeting, it's not anticipated that Noor will be acting for the syndicate when it takes the mortgage. And actually, when you look at the evidence that you're being provided with from the chairman, What the meeting is about Noor demanding more security for itself. That's what's being alleged, and not just that, demanding more security for itself in order to participate in its capacity as a lender, not in any capacity as an arranging bank. And you have the point that the banks are said to have been unaware of this. That's all I was going to say about agency. In relation to, you have my other points on that. Ratification, very briefly. Now, what is said is that this is all about the application of the proceeds of the OBN security. Now, in relation to the facts, as I've given you what my instructions are, that the OBN security was actually executed by a third party, albeit Noor Bank did receive some benefit, about 20 million dirhams, but that was 20 million dirhams which was not applied to the finance documents. So my learned friend took you to the provision of the agreement, which says if the money is applied to pay down any elements due under the finance agreements, under these facilities, then it needs to be shared. But so I'm afraid I haven't been able to get you a witness statement. There is one in draft, and we will provide that as best we can at this stage as to what exactly has happened in relation to that. But it doesn't turn on the facts, because the point goes nowhere. Because what my learned friend says is, well, the effect of receiving money sometime further down the line is that the contract was ratified. But what he needs to show is that the unlawful acts were either ratified or known about before the contract was entered into. So the ratification of a contract doesn't ratify unlawful conduct which led to that contract, and therefore make the contract somehow voidable. So there's a logical disconnect between the sort of ratification that he asserts and the remedy that he would seek.
You say what has to be ratified is the unlawful threat.
Correct, or the unlawful misrepresentation, or whatever it may be. Or alternatively, you have to.
Which is it?
I'm sorry?
I'm trying to think through what it is that has to be ratified. Give me your submissions on that.
So it would have to be the unlawful threat. So the law on that is that the third parties to the threat, if I can put it like that, would need at least to have notice or constructive notice of the unlawful threat before the contract was entered into. So that's in between the 16th and the 27th of December. In relation to the question of ratification, you would have to have a representation or a promise, I suppose, which was purportedly made on behalf of the other syndicate members, but which was made in an unauthorized way.
Yeah.
And then that would then need to be ratified, that conduct, that false representation, or alternatively, the contractual entering into to bind them into the contract, I suppose, would need to itself be ratified. As far as I mean, I don't really understand the argument. It may be that it's bound into the contract case, I suppose. You might be saying, once you ratify the OBN security, you ratify somehow this. I think it would have to operate by reference to the implied term, because he'd have to say there's some sort of unauthorized offering of a term to the effect that they were going to comply. Everyone was going to be bound into Noor's obligation to comply with the obligation to provide working capital. But it's all very difficult, and you'll notice the provisions in the contract which I drew your attention to, which say any failure by one finance party to provide finance under the terms of this agreement doesn't excuse payment to the other finance parties. So I just don't think it goes anywhere on the contract side either.
Can you just give me the cross reference to that clause again?
Yeah.
I could deal with the cross reference not only to that clause, but also to the anti-set-off provision.
Yes, thank you. I can give you that right now, or I can give you it.
Well, whenever convenient. Whenever convenient.
I just don't have it in front of me. I'm sure someone will email me with it very shortly.
Yeah, okay.
Thank you. In relation to sorry, bear with me 1 second. I'll let you know when they come in. In relation to the question of affirmation, on the question of knowledge, I won't go back to the sort of facts. My learned friend doesn't say anything about the payment of interest, which we say is very clear affirmation, and also the July further Marapa in July. But in relation to the question of knowledge, the knowledge of the right to rescind, it said, oh well, this is a UAE company. And you will have spotted, I'm sure, that the chairman refers to the Group General Counsel, Gail Hanlon. That's a paragraph 51 of his witness statement, page 1325. So clearly there is legal function within the group as a whole. We don't know her nationality, but it looks from her name like she is a common lawyer. In other words, and also we know that this is a group that is signing up to contracts, large contracts, on the basis of English law. It is quite something for the group to say, as a group, despite the in-house legal function, despite having general counsel in place, we just didn't know what our rights were when it turned out that we didn't get what we were promised, even though that brought the group to a crashing halt. By August, we don't say anything about it until December. So the knowledge point, we say, is just fanciful. And I won't repeat facts that we say amount to ratification. In relation to the unlawful act, your lordship, my learned friend talked about the best endeavours clause. Your lordship said yes, there's a debate about where the extent to which that can require a party to act contrary to their financial business interests, and I accept that. Where there is no debate is that a clause of that sort cannot mean that the party has to go beyond the terms of the contract. Your lordship is well familiar with this area and knows that the effect of those sorts of clauses cannot require a party to go beyond, for example, and vary the existing terms of the contract. It all has to be confined within the terms of the contract. It is a short point of construction. And the point here is that this is on the question of there's no commitment to finance, whether or not that can somehow be overridden. It's a short point of construction. There may be arguments about the scope of the duty of best endeavours, but where there is an express term, whatever the limits of that duty are, they can't go so far as to require lending. And I think my learned friend made a sort of new allegation in a way, which was that, oh, well, it's not just the threat not to participate, it's also the demand of security. But obviously the demand of security follows from the refusal to lend on the basis that the newer bank already had security. And so if they don't lend, they're going to keep what they have. I think that the short answer to that is there's no independent breach of any kind in requiring security or additional security to lend, which is over and above, different to the particular provision that he's relied on. My learned friend talked about what he describes as my pleading point, which is that my point here is in relation to the effect of the duress. How can he make out his duress case when he said, I heard him say, his case is that there was the group had no choice as a result of the threat but to enter into the facility. But the point is that's what they were going to do anyway. And they say in terms they had no choice but to enter into the facility. That's the centre of the duress, is that they needed the facility, come what may. So your lordship alighted on the point, the impact of the duress is actually on the entry into the security, not on the facility. My learned friend made this point about the Marm case, which talks about the interconnectivity of two agreements. And one has to look at the relationship between those two agreements. What is the scope of it? Because the critical factor in the Marm case was the interconnectivity between those two. It was a term of one that the other should be kept in place. What the decision, which is obiter, by the way, cannot be seen as saying is that the mere fact that one contract is demanded as a condition of another contract cannot by itself mean that the second contract falls with the first, because otherwise duress would always bring down both contracts, because it's essential to the duress that you say I won't do contract 2 unless you give me contract 1, but you've already committed to doing contract 2, so you're making an illegitimate demand to do contract 1. And so therefore in every case of duress you'd be saying, well, both contracts now have to fall away because they are connected in the appropriate way. You're always, the whole point of defence, duress, the essence of duress is that you're demanding something more to do something that was always going to be done in the first place. And it's worth just pointing out here as well that there is we see an inherent inconsistency in the way in which the case is put, because on the one hand, my learned friend has to say, this is all one big contract. And so duress that affects one part of it brings the whole thing down. But on the other hand, he has to say, well, I accept you can't now unwind the OBN security provisions because that's been executed and that's all gone by the by. But you can unwind the other part of it. It has to be one or the other. Logically, either it can, or it all has to be unwound, or parts of it can be unwound. If it all has to be unwound, it can't be because the OBN security has been performed. If parts of it if only parts of it can be unwound, there's no grounds to go after the security, the financing. Very briefly, and I don't have much more, on collateral contracts. My point here is not that there's no formal written agreement and that it's all done. Sorry, my point about uncertainty here is not that there's no formal written agreement and that it's all done in a rush. I have my forensic points about what objectively could have been understood to have been promised at that meeting, but I put those to the side for now. The point here is to say, I will give you, even if it's 100 million, I will give you working capital for 100 million. It just is not sufficient it's not sufficiently certain to amount to a binding agreement, because it's not about reducing it to writing. It's a more fundamental point. You don't have the principal terms, and ultimately you don't have any terms at all about what the group was going to provide. So even if you accept that there's sufficient certainty about what the banks were going to provide, we're going to give you X amount of money and we're going to give you it by a certain amount of date, we're going to give you it for a certain purpose. You don't know anything about what's on the other side of the transaction. Like me saying today, I promised to sell you my house. Well, for how much? For what? We don't know what the price is in the interest. Unless you buy this argument that there was some sort of promise to do this on an unsecured basis, which actually isn't alleged, and it's certainly not evidenced, then you don't have any bargain as to that central term either. The problem is either in relation to security, you either don't have agreement there at all, or it just adds to the deep improbability, we say, of the assertions that are being made. In relation to the implied term case, I don't follow it at all. As I understand it, actually what's being said is that there is an express agreement. It's not an implied agreement, it's an express agreement.
Well, I understand in the end, Mr. Fraser, although he didn't accept it, the effect of what he's saying is it's collateral agreement. You know, his implied term argument amounts to a collateral contract. And that's
so a side agreement. I just make the short logical point. It has to be outside the facility, because he's saying that the term is an obligation to enter into the facility. So if the obligation to enter into the facility is in the facility, you never get to the obligation. So it has to be outside.
Well, that brings us back to the question about what the contract is on the basis of the chairman's witness statement. You drew my attention a moment ago to paragraph 34, which says that Mr. Vig told him that working capital would be available if the mortgage of OBN assets was supplied. But when we get to paragraphs 42 and 43, it's not expressed in those terms at all.
No. So that's right. And so when we get to those points, what he is saying.
Well, that's not quite right, is it? The question is how one reads 42, 34, 42, 43, and 47 together. And I suppose I should perhaps have pressed Mr. Fraser more than you on it, but it would help me to know what your submission is as to what is truly the case that is put forward, not what's pleaded by Mr. Fraser, but what the witness is saying.
Well, I'd understood the centre of it to be the first sentence in paragraph 43. And so that the case is that there was a guarantee to provide 100 million minimum by March 2019 at the latest, full stop. So my understanding was that was what was being said. It's not so much that there's a contractual agreement that they will go to the syndicate to try to get this, but that they will just underpin the guarantee that in the event that they can't, or the event that it doesn't happen, then they will provide 100 million in working capital. So that's why I say, as far as I can tell from that, in terms of what is being said in that evidence, there's no assertion that that is in any way tied to the security that's being provided for the separate purpose of entering into the facility.
Well, paragraph 42 is on the basis of arranging 350 million from the syndicate if the syndicate is provided with security over OBN. And the question then is how you read paragraph 43 in the light of that.
Well, it couldn't be under the terms of the syndicate agreement, because it would have to be a bilateral arrangement. So if you're suggesting, I mean, there's only two logical consequences, aren't there? One is either there's going to be a side deal. Well, I think in both cases there has to be a side deal between Noor and the group for the provision of 100 million dirhams in working capital by that date, And the only two conditions are either Noor provides that completely unsecured, or alternatively there's going to be a commercial discussion. But there's no way that that could be arranged by reference to the security that's being provided to the syndicate. And so you get this further suggestion, oh, well, because they provided OBN security, then somehow it could be tied into that. But that's not what I see. I mean, I don't see the evidence saying that.
If you go on to the latter half of paragraph 45, where he's saying why there's no inconsistency with the desire to reduce exposure, he says if more security could be provided, this would increase the level at which they, by which he means, at least as I read it, Noor, could lend to the BBIH group.
Right, but that's his response.
So this is talking here about the OBN security being separate security for Noor as opposed to the syndicate.
Yes.
While they would be reluctant to provide working capital if this was only secured against the same assets as the syndication, this would not be the case if they had valuable additional security in the form of OBN. And then, as I pointed out to Mr. Fraser, that's then inconsistent with what he says in paragraph 47 about his understanding he was giving the mortgage incapacity as lead bank to the syndicate.
Yeah, that's right.
So
I mean,
my question is quite: what is the representation, warranty, collateral contract that is alleged in paragraph 43?
Yeah, and I think what's important to note when you're considering that is that the parts of paragraph 45 that your lordship's just taken me to are not reports about things said in the meeting.
No, they're not.
So none of that forms the basis. It's simply his extrapolation from what he said was said. So as you say, on the one hand, in places he's saying this is going to be security for Noor, and on the other hand, he's saying this is going to be security for the syndicate. As I'd understood the general thrust of the evidence, it was that this is security being provided to Noor because Noor wanted security to enter into the syndicate. That there are, though, as your eyes have seen and picked out, statements which are inconsistent with that. But it doesn't. Those other statements don't make any sense, and so the proposition that this was to get security for the syndicate as a whole doesn't make any sense when one considers the commercial backdrop, which is you've got one bank saying we're overexposed, we don't want to expose ourselves anymore unless we get more security. And if they get more security, that has to be shared effectively, pari passu, with the other participants in the syndication. They're not getting what they say they need to give them comfort to get into the syndicate. And that goes to the agency point, but your question is really about what's being promised, what's being said to have been promised. The answer is one starts with the proposition that what he's reporting, I suppose, is we guarantee we will give you 100 million. But on what basis? What he doesn't say is we guarantee we'll give you 100 million and we'll use this OBN security as security for that 100 million. There's no report of that assertion. It is literally, we will give you 100 million. That's why I say it just is not going to be sufficiently certain on terms to amount to any kind of binding promise, whether you call it a contractual promise or whether you call it a representation that or implied representation that can be reasonably relied on.
Right. What is your submissions about my characterization issue about promise, representation, etc.?
I accept that a statement of future intention can carry with it an implied representation, but you would have seen in the authorities that it is important to keep those two things separate. They are distinct concepts. One is a promise, a commitment to do something, and it's not going to be in every case. We didn't press it in our written submissions, but as I say, one can't just simply elide the concepts and say whenever somebody promises something, they make an implied representation at the same time. That's not the position in the law.
No, I mean that's the whole basis of a contract.
Yeah, quite. So and there's nothing here that takes us outside of that. There is a, put it this way, there is a legal distinction between, on the one hand, a promise and a representation. It is possible to promise something without making an implied representation, and it's not in every case you do that. You need something additional. You need something to suggest that that is what is going on in these circumstances. But I wasn't going to press that point any further.
Yeah. But I do want to press you, and I perhaps should have pressed Mr. Fraser hard on paragraphs 43 and 42 and 43 again of this witness statement. The case as pleaded is that they, unless the OBN security is provided, nor won't participate in the syndication.
Yes.
Case as put in paragraphs 42 and 43 is everything is about working capital. They will arrange 350 million in working capital to be advanced after syndication is closed if OBN security is given. He wants 450. Noor says they'll try to arrange for 450 to be advanced. And then even if the full 450 is not arranged, they guarantee to provide 100 million. With, I think, the inference, as we've just discussed, that they get the security, the OBN security. There's nothing in here at all about not participating in the syndicate itself.
Oh, that comes in paragraph 40.
Oh, I've missed it. Thank you.
It's in the middle of paragraph 40.
Quite
So
right.
at the beginning.
Thank you very much. Yeah,
sure.
Absolutely.
And I think we accept. And one of
Yes.
the points my learned friend said is we've changed our case on this. We haven't changed our case on this. If you actually read our pleadings, what we say is we accept that we said at the meeting, yes, in order to participate in the facility at that level, we're going to require further security.
Yes. What you deny is it was a threat to withdraw.
Yes, correct. There's nothing to withdraw from. That's why I said, well, if you actually read the pleadings, I can give you the reference to my learned friends making faces, but it is in fact the position that we have not changed our case on this at all.
No, well, I've read that because the denial is that you have the threat to withdraw, whilst you say that you did make it plain you wouldn't participate in the syndicate unless you had additional security.
Yes, quite.
Yeah.
There's nothing to withdraw from until there's a syndicate.
I understand the argument. Yeah.
Yeah. My lord, I know you wanted to press me further on 42 and 43. Have I given you what I can in relation to that?
I've gone as far as it can possibly go. I shall give Mr. Fraser the opportunity to say anything further if he wants to.
That's fair. My lord, then I was going to talk about Sharia.
Yes, thank you. Yeah.
You asked the question, what's the status of a Sharia, of a registrar's direction? Is it a rule?
Yeah.
The answer is it isn't a rule. It's not even a practice direction. So just to give you there is, for completeness, one reference to registrar's directions in the rules, but it's rule 1.4, which says any rule amendments must be made by the Chief Justice. Rule 3.16 which permits practice directions, but they may be made by the Chief Justice. The only reference in the rules creeps in the Technology and Construction Division rules at 56.7, which does refer to 56.7, sorry, it does refer to registrar's directions generally, but there is no, if I can put it this way, there's no rule machinery conferring any power onto the registrar to make these sorts of directions. And so
what's the reference you've just given me?
Sorry, the first reference was 1.4.
I've got 1.4 and 3.16, yeah.
So the only other one was 56.7, really for completeness, which just refers to the rules, registrar's directions as being a possibility.
Right.
Registrar's directions, actually, that's the only rule which applies registrar's directions to any claims, and that's TCD claims, Technology and Construction Division claims. So there's no rule machinery imparting authority onto the registrar to make those directions. One might want to have regard to them, but it does seem to me that their effect cannot be to override the effect of a Court of Appeal decision. And the context of that registrar's direction is quite important, I suggest. If we go back to it, it's at tab 85 of bundle F. And in particular deals with the trust law and says that expert evidence, this may become relevant, for example, in the context of the DIFC trust law as amended. And it says under the DIFC trust law, the DIFC courts may be asked to give their opinion, advice and direction about any matter concerning a trust. And the court can make orders inter alia about the execution or administration of a trust and the correctness or propriety of the conduct of trustees. And so the whole context of this registrar's direction is looking at the prospect of applications to the court, asking the court to say whether or not particular structures comply with Sharia law. And so obviously that raises particular sensitivities where you've got, in effect, the court being asked to sit as a Sharia board of some sort over these sorts of trusts without having any reference to Sharia law expert evidence. But so we're not in that sort of context. What the context we are in, at least on the pleadings, is to say these are contractual provisions that you have to import. And the question here is whether or not you can sense check these allegations. And your lordship said, well, I'd be a bit reluctant to do it, but just one has to ask the question, is it enough just to cite some principles of the EOFI standards, say that there is a breach of them, and say, oh, well, now we're off to trial on expensive Sharia law evidence? And so just by way of example, we've got this argument that there's a breach of Sharia because the contracts, the Murabha contracts, don't set the profit in advance. You can look at those contracts and see that the Master Murabha is not a Murabha contract. It's a framework agreement, and when you get to the Murabha contracts, they do set profit in advance.
Yeah, well, I don't have any difficulty about determining questions of fact where the meaning is clear.
Yeah, and we say the meaning is clear because what my learned friend does in his pleading, at least, is to try to incorporate these principles into an English law contract. So they need to be construed. And so to the extent that you actually have to construe them, and we say actually they're clear enough, then they're construed as provisions of the contract. So we do say your lordship shouldn't just take the position if you get there, and you may not get there, but if you get there, your lordship shouldn't just take the position that, well, it's all Sharia law, so I'm just going to put a box around that and send that off to trial. Your lordship should be in a position the way I put it is to sense check those allegations, because and a particular problem that lots of us encounter when we deal with Sharia law issues, and one finds this when you've got contracts governed by Saudi law, which is effectively Sharia law, is that huge swathes of it are not codified, or at least not codified in one direction, if I can put it like that. So it can be very hard to find hard principles, and one has to read very widely to get from that what the principles are. But here they are saying there's a particular standard which imposes a particular requirement, and we can look at that requirement and see whether it's been met. So the problems surrounding Sharia are not so acute. My point about incorporation was that simply that when one looks at the particular authority that was relied on, there's a distinction drawn between the express words of expressly incorporating regulatory provisions on the one hand, and those which just refer to them. And I say when one looks at the recital in particular, it's not a term, it's a recital, but also when one looks at its language, it's not an express incorporation. It's a statement by both parties that they consider that this is all being done in accordance with Sharia. That's not sufficient to say, well, it's now an obligation that be the case. My learned friend referred to my logical flaw, what he called my logical flaw point, as a hindsight argument. This is my point, that if you interpret the contract in the way that he says you should interpret it, the result is a void contract. That's not a matter of hindsight, because he says that the whole thing is void from day one. So the answer has to be that the parties intended by those words in accordance with the Sharia to impose standards which they hadn't actually complied with, and therefore made it void. I referred to what I called the grace period in relation to these standards, and your lordship will know that the way this all works within the banks is there's a Sharia board within the bank that approves products, and the standards or the resolution, the higher Sharia authority resolution, which we looked at yesterday, is imposes obligations on how those Sharia boards should act within the banks. And what happens is the boards approve the transactions, and then those go out. They're then rolled out to clients. So you have a fatwa which approves this kind of deal. And the point is not just that there is this grace period and therefore there's no breach, but this totally undermines his argument that the result of any breach leads to it being void, or that it could in any way be subject to a public policy point, because it expressly allows for this grace period of 2 years. And in that period of 2 years, there are going to be contracts out there under the terms of this agreement. Under the terms of this resolution, expressly allows that there will be contracts out there which are not consistent with the AOFI standards. That's the effect of saying you need to give us a plan to show us how you're going to get yourself into line with these standards. That clearly shows that the resolution itself anticipates that there will be agreements out there which are not consistent with the standards. So that dispenses with the argument that all of those agreements are somehow void, or that some breach of the standards leads to them being void. And it dispenses with the argument that there is a public policy requirement that those agreements not be consistent, and so it cuts across also his response to my estoppel and waiver points. My lord, you asked for the references to those provisions. The no set-off clause is at page 978 of the bundle. Sorry, I don't have a particular provision. Yeah, it's clause 26.6. And then the other provision we discussed.
This
is
is
in, this is in the common terms.
We're looking at here.
Common terms agreement.
This is CTA, yeah.
Yeah. And then the other provision is at page 916, also in the common terms agreement. And it's clauses 2.2.1 to 2.2.3. The primary one being 2.2.1. But I don't think any point arises in relation to that, because my learned friend accepts that, for example, if he loses on agency, then he's left with a counterclaim against Noor.
Yes.
Well, unless you've got any other questions, those were going to be what I was going to reply to. But I'm obviously here if there are any others.
Bear with me a moment.
Of course.
Yes. Thank you very much.
Thank you.
Mr. Fraser, if there's anything you want to add, because I've asked various questions of Mr. Montague Smith, here's your chance to do so.
My lord, I don't think I can add anything to what I've previously submitted.
All right. Thank you very much then, in which case I'll reserve judgment.
My lord, I do apologise for interrupting. I had mentioned that there's a draft witness statement in train to try to answer some of these factual points that have been raised. I mean, I don't know how you want to deal with that. We can sort of try and serve something today which sort of deals with this question of what has happened with the OBN security, for example. Your lordship mentioned that in relation to the calculation of interest, if we get there, we can deal with that in due course. So we'll put that to one side for now. But I don't know how you want to deal with the other aspects of it.
Well, I think there should be a witness statement as to what you told me on instructions.
It may be from solicitors on their instructions, but we'll do what we can in the time that we.
The only point is that if you produce that, then Mr. Fraser must have the opportunity to say something about it.
I understand that.
I could put in written submissions, and
Yes.
potentially even any evidence if there wasn't any opposition, but within a short period, depending on, let's say, 7 days within the period of the provision of the witness statement. I don't know how quick your lordship is thinking about delivering judgment, but would that be a sort of timescale your lordship would go with?
But I was thinking of, because of other commitments, I will probably write the judgment today and tomorrow, realistically. Having said that, it needs to be proofread and various processes gone through by the court so that it's unlikely to come out before the middle of next week.
Thank you, Mark.
So if Mr. Montague Smith was able to produce something today, then you could produce something on Monday, Tuesday, Wednesday next week, something of that kind. Does that fit?
Yes, my lord, we certainly want to fit in with the lordship's timing. So if we were to, if something was produced today, then let's say close of play Dubai time on Tuesday.
Yes.
I'm being told we need a little bit more time.
Right.
I'm not quite sure why, but I mean, I've obviously been given those instructions, and no doubt those instructions can simply be recorded in a witness statement, but they won't say more at this stage, I think, than that, I'm afraid. But I haven't read the draft, so I'm just hesitant to commit to providing you with something which it turns out I just can't produce in the time that's available. No. It may well be that nothing really turns on it. There are numerous ways in which this might not.
Well, understood, but until I've sat down and
yeah, I understand that
draft, I don't know the answer to that.
Right. Can we leave it like this? I will push as hard as I can to produce something. If it turns out it won't be available by the end of tomorrow, we will let the court know and give you a timetable in relation to that. And obviously there has to be a limit to it. And if we can't produce it within a reasonable period of time, we'll just have to take those assertions as unevidenced.
Yes, and shall I give Mr. Fraser 48 hours to respond to it with liberty to apply?
I think we'll be reasonable, won't we?
Would 72 be reasonable?
Perhaps 2 working days, right? So it doesn't come in on Friday, and he has to do it by Sunday. But yeah,
I meant working days. In fact, yes.
Yeah. But 3 working days is all I.
3 working days.
3 working days if you need it. But
thank you, my lord.
There we go. And in relation to any issues that arise on interests and costs, obviously, if interest is involved, the date matters as to when the judgment is to be issued and to how the calculation takes effect. But it presumably can all be dealt with on paper rather than trying to fix a hearing in the way the English court does for formal hand down and so on. I mean, that doesn't seem to be necessary or helpful.
I would hope so.
I would say here, we would hope so.
Yes. Okay. Well, that's helpful because I'm in arbitration for I'm not quite sure how long. All right. Well, thank you all very much indeed. That's all very helpful, and I'll wait to hear from you, and you'll wait to hear from me, or the court, I should say.
Yeah.
Very good. Thank you very much indeed. If you'd all like to sign off, I'll have a word with the associate, if I may.
Thank you, my lord.